the unknown, down the rabbit hole, where it stops no one knows. We're going headed into the unknown. Na, 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 na.
Hi, everybody. Happy Friday, even though it's Friday the 13th. Getting ready for Halloween. You know, setting up the Friday the 13th, and then Michael Myers will be out. Don't worry. So, hi, everybody. Happy Friday. Thank you guys for being here. Welcome back to Criminality, or if this is your first time here, welcome to Criminality. I appreciate you guys being here. It is a Friday night, so I know that Friday Night Lives and Saturday Night Lives, for whatever reason on this channel, get a little off the hook. So you guys keep your naughty in the bag for a little while, at least through the first hour. But we have Travis back tonight. He was with us last night, and he obviously has so much information and so much research that he's done that we couldn't fit it all into one night. So he thankfully came back tonight to continue the discussion from yesterday regarding the third-party culprits, and to give us a little bit more insight into that. And then we're going to be dipping into Dawn Perlmutter's testimony and all the information that he has researched regarding that. So I'm going to say hi to you guys real quick, and then I'm going to bring him up. But before I do that, I just want to apologize. So last night during the live, I started to feel kind of under the weather. It's been a little bit rough today. I feel like I have like a stomach bug. I'm not like super sick, but I just don't feel great. So if Travis takes over, and then Sleuthy has the link, so she'll come up whenever she's available. But just wanted to kind of give you guys a heads up. Like last night I was kind of in and out, and then I'm just, doing the best I can tonight. And then I think Travis actually got a little bit of a stomach bug today too. So I don't know what's going on, but it is what it is. But I'm going to say hi to you guys, and then we'll bring Travis up, and we're going to get started. And like I said, no naughty until at least after the first hour. I know how you guys are on Friday nights. Don't you try to pretend otherwise. Hi, Kel. Hi, Adrian. What's up, young black economist? Hi, post-punk mama. Oh, it's okay. Yeah, no, go to bed, T. Yeah, I wish I could. But even if I wasn't on here, I still have to go do mom stuff. So, hi, Criminal Network. Hi, Nicole. Everybody loves bacon. Now everybody's going to be hungry. So is that what started you guys down this rabbit hole of who's eating and drinking what? Hi, Scarlet Letter. Hi, Snappy. I'm not naughty. I'm just telling everybody that I have never heard of Raspberry Uncrustables, so I'm going to have to look for that. Yeah, 8675309. Yeah, you're innocent. Hi, Christy. Unnecessary Evil. Did I say hi to you? I'm probably going to end up just saying hi to the same people over and over again, and I apologize. Hi, Catastrophe. Hi, Heavy Metal. What's up, Angel? Hi, Jessica. Hi, Thomas. Us naughty? What? Yeah, Hi, Jen. Hi, Jamie. Hi, Luke. Post-punk mama, I think I said hi to you. I'm not going to remember. I apologize. Hi, Tammy. Hey, Rochelle. Let me see. I'm going to probably end up missing you guys. You're going to be like, what about me? What about me? What about me? Hi, Carla. Hi, USA Libertarian. Hey, Shaz. Just trying to scroll up. Hey, Susie Q. Captain America. Captain America's here. I've got Gatorade. Jenny's got Gatorade and Uncrustable and THC gummy. Well, I mean, it's settled in for a Friday night. I like it. I have a bowl and a hard seltzer. That works too. All right, let's see who's down here. Hey, Amy Lou. Let's see who's just popped in. I chopped and stacked wood all day. So heck yeah, you deserve a beer. Sweet. Hey, Amy. Had to have a fun dinner on this dreary Friday night. So we had sprinkled pancakes and bacon. That's so fun. Drink peppermint tea. It will help settle your tummy. Okay. I have peppermint stuff. I love peppermint. And hey, True Crime Fangirl. Okay, I'm going to bring up Travis, and then I'll try to say hi to you guys in chat. But if I missed anybody, you just know that it's my brain that, sometimes doesn't function, and it is what it is. Hi, Digital. But thank you guys for all being here. Ticking time bomb. All right, we'll bring Travis up. Hi, Travis. Welcome back. Long time no see.
Thanks for having me back. Hello, everybody in chat. Heard a lot of familiar names from yesterday.
I think the gang's almost all here.
Ate something similar. Both got something going on, but glad the day is over and glad to be back.
So we're going to start out talking about kind of where we finished yesterday. I was hoping that Sleuthy would be ready by now because I know that she has a lot of questions on the third-party stuff. But let me pull up kind of what we were talking about.
While you're doing that, remind me before we end, we need to save 10 or 15 minutes because I found more stuff in Sleuthy's spreadsheet that I think are more, what's the modern term for hidden stuff that's really cool? Easter eggs. I found some more Easter eggs.
Okay. All right, we'll do that. Okay, so first things that we kind of wanted, some of this is just a refresher so that we're all, kind of on the same page with what we're talking about. But like the motions and stuff are old, already have rulings, but just to kind of go back over so we can have a better understanding on the legal side of things. So this is Nick's motion in limine, where he talks about the third party information, which we had touched on yesterday. If you guys were here for yesterday's live or watched it on replay, thank you for that. We were kind of going over where in her ruling, she talks about Odinism, cult, ritualistic killing, and then she goes through the list of names. And I was like asking Travis, I'm like, it doesn't really make sense. Like, how do you have, like, how could she say they can't bring up like a third party, like almost essentially a motive versus the actual people? Like, how could she make it so they can't talk about Odinism when law enforcement was actually, investigating Odinism and the likes of? So this is kind of what we've gone back and forth on yesterday. And so now we're back today. We're going to kind of take a step further back and we're going to look at the motion in limine and number 7 specifically. And it talks about any attempt to introduce evidence of third-party motive that is not relevant and or the probative value is outweighed by unfair prejudice and confusion of the issues or has the potential to mislead the jury in violation of Rule 401. So it is kind of encompassed in here about even just the third-party motive. But to me, I still feel like it's two separate things. If you're not introducing an actual third party, I don't know how Odinism wouldn't show enough of a nexus when they literally investigated it for years. So I'm going to pass that to Travis so he can kind of break down his thoughts on it.
Yeah, they lumped, they are two separate things. They've lumped them in together. And they talking about, so they're talking about third-party motive is not relevant, and they cite Ausbrook and Pelley. I didn't pull up either one of those, but while we're going into the next stuff, while we're talking about some stuff later, I'm going to pull that Pelley case to see what it's talking about. But then they switch gears. Before any such evidence may be permitted, and again, what they're referring to is motive evidence. Before any such evidence may be permitted, the defense must show some connection between the third party and the crime. Holmes, the Supreme Court case, and then further, it must be a direct connection based on admissible evidence and not founded in hearsay, speculation, rumors, conjecture, or theory, citing the McIntyre, Magaha, and Tibs. And then I pulled Tibs for no other reason that's most recent, so we can look at some of the language in there. And then they've talked about motive at the beginning of number 7, and then that relates to how she ruled later on in her order granting the motion, but says the order will not permit the evidence submitted by the defense in support of their arguments regarding third-party perpetrators. This must be the
This was the order. I just flipped over to it because you brought it up.
Gotcha. Okay, so flip up the paragraph before that, just up a little bit. Yep. So yesterday, where it says that it relates to paragraph 7, the burden is on the defendant to show a nexus between Odinism, cult, or ritualistic killing, and then people's names. And I'm like, well, that doesn't make any sense. Normally, you got to show a direct connection, and it's got nothing to do with motive. You can always attack an investigation, but we see now that you pulled up the original motion in paragraph 7 that they start off by talking about third-party motive. Again, I'll pull up that Pelley case, but I'm guessing that case says the defendant tried to enter some sort of evidence that another person out there had motive to do the crime. It's probably a murder, had motive to kill the person. And they said motive wasn't enough. Then they switch. Before any evidence should be permitted, must show connection. They're referring to motive evidence on that you got to show a direct connection. That's what the law is everywhere else. They just don't break it down. Motive, direct connection, opportunity are all requirements of third-party perpetrator evidence. I'm just going to use what Indiana calls it, third-party perpetrator. And then further, it must be a direct connection based on evidence not founded in hearsay. While that's true, when we look at whatever point we look at the Allen case cited by the defense, there's that case I mentioned yesterday out of Kentucky from 1986 that says, generally it's got to be admissible, but if there's good, solid evidence that somebody else committed the crime or fits the requirements or is the basis for the defense, the defendant is advancing, the rules of evidence need to give way. So it's kind of a balance depending on how strong the evidence is. But we'll get to that in a minute. So I'm
still confused though, Travis. I don't understand if there was an investigation into this crime scene and law enforcement themselves spent years looking into this religion, learning more about it, trying to understand it, looking for evidence when they were searching homes in regards to it. How does that not create enough of a nexus between the crime scene and Odinism? Like, take away the people, take away all the third-party people, and just leave that.
There's no. If you're asking me to dig into the court's mind, shame on you. I just can't do it. But seriously, I agree. That, and we discussed that last night for the people who weren't here on that. You're always able to go into why didn't you investigate these people? Nobody specific, but, why, you had a group of people in the house with John O'Keefe lying dead outside. All of that was allowed. Why didn't you go knock on the door to talk to those people?
Right.
Why didn't you get you could have gotten a warrant, on and on and on. And case after case after case, same thing, that not only did you suspect Odinism, officer or detective, you went to Purdue and hired one of the country's most well-known, well-respected experts on runes to give you advice on it. And there's actually another pleading where the last pleading that was filed after the hearing, it's defendant's brief in support of opposition to motion in limine. They repeated again these different arguments, asked the court to take judicial notice of testimony, and went all the way back to that first hearing where McClellan made 3 separate times statements that he wanted the PCA to remain sealed because the investigation wasn't done. They were looking into other people being involved in the murders, and so yeah, it's quite a conundrum to figure out why even motive of that they frame as motive, but that Odinism would be out since it's the state's own investigation that included that.
Right, and it would almost fall into the same types of like cross-examination as the Karen Reed case too, because it's the lack of follow-through. So it's like, so you had search warrants for other people's devices that you chose to not go and do, or not follow up with. You had search warrants for other people's homes that you chose not to follow up with, and you just didn't do it. And now, like, I don't know how they can even get that in there when it has to do with these quote unquote people. But
yeah, I agree, because it doesn't always work the way it did in
right.
Karen Reed, to the extent that it did work. Why didn't you do this? Why didn't you do that? Because it may be that, but these people have been deposed and so on and so forth. Talking about the detectives, because in Indiana you can take depositions in a criminal case. A lot of these people were deposed, a lot of stuff found out, but hypothetically it could be, okay, you're the one who brought it up. You're the one who went and got an expert. At first you said you couldn't remember the expert's name. Then all of a sudden you figured out who it was. I guess probably because the defense figured it out on their own. And so that detective had to give the info up anyway. But but it could be that, well, yeah, initially we were looking at that very, very closely, and we did talk to that expert and got that information, and then the investigation continued on, and then we learned more, and then they would have to lay out, we learned this, and this, and so we had to go in a different direction. If that's the case. So sometimes, this stuff can be a big nothing burger. But that hasn't been laid out, that it's nothing. That I saw in the testimony. I mean, you guys did a read through of it. Was it well established in the testimony that, this is all a bunch of hooey. It's just smoke and mirrors.
The problem is that we don't have the full transcripts from those 3 days yet. So, and part of what we're missing is the Murphy's and Click's testimonies regarding their investigation into the third party. So we don't have those to go off of. So I don't know how well they presented the investigation. I mean, we have people who were there who've told us, and depending on what side of the fence they sit on, it's very, very different. Some say they did a great job. Some say they didn't do a good job. So without them, we're kind of just here stuck in the middle still.
Right. And, it's not a trial within a trial. I mean, the court's not supposed to be going, oh, okay, well, I've heard everything. And, I just don't see how Odinism is connected. If it would be enough to show that was part of the investigation and experts looked at it. The defense has their own expert on it. That would be enough typically to at least attack the investigation. Third-party perpetrators, specific individuals, no, you got to make a further leap. But even if there's just a smidgen of evidence that the investigation was biased or flawed, didn't go far enough, they didn't follow up on things, that's enough.
Let me give you an example then. So let's say that Holman's on the stand or any of them, Purdy's on the stand, and the question comes to what was your first, what were the first steps that you did in this investigation? What were the first things that you guys were looking at? And I mean, how do they just, so the person on the stand just avoids saying Odinism? You know what I mean? So how do you keep it out when it was a huge part of what you investigated? Would they not be allowed to ask that question because it's just not relevant?
You're so smart. So there's not the language here. Normally at the end of a motion in limine, the court backs that up by saying, we'll instruct counsel for the parties, will instruct their witnesses. They'll advise them of this ruling, and they'll instruct them not to mention these subjects in front of the jury. And it can be fashioned. And so they just would say, so how did it start out? And then he mentions everything, but doesn't mention Odinism, and it's on cross. We did A, B, C, and D, and up through, and then O is Odinism. And he skips over O and goes to P, and then, okay, was there anything else? And the witness knows he skipped over O. Well, there were some other things, but I believe they're the subject of a prior order. And then that's if Nick hasn't clued in already and said objection, relevance. This is the subject of a previous order by the court. Then approach, and so if the witness wasn't briefed, that's how it works. The main investigator, Holman, going to brief, hey, Odinism's out. The only way it's coming in is if we open the door. So if they ask you a question and it calls for the answer on Odinism, what you say is, I believe there's an order regarding that, and that clues people in. But that's how it's handled.
How does this doesn't make any sense? So Catastrophe said that the Pelley.
Well, let's do another example. So let's say, and this happens a lot. Let's say that it's a murder case. They get the suspect in, they're examining him, and he just, he won't back down. You take a polygraph. Yeah, I'll take a polygraph. And this is actually, I think people can see for themselves. This is part of American Nightmare documentary on Netflix, 3-part documentary series about a couple that were a victim of crime, and then things got turned around, and they became the suspects in the crime. And very interesting documentary. But typical tactics. Will you take a polygraph? And but anyway, so they actually have the suspect take the polygraph, and he passes with flying colors, let's say. And so that's not coming in, and the lead detective may be the department's polygrapher, lie detector examiner, and they so they're on the stand, and you're okay. What did you do next? Everybody knows that there's an order that not going to be in any mention that had my client do a polygraph, not even the mention that he took a polygraph, and certainly not that he passed the polygraph. And so it happens all the time that these things get fashioned. Okay, so he denied he was involved in the murder. Isn't that right? And he talked to him for an hour and a half. And then, what did you do next? And then sometimes they'll come back and say, you mean immediately next, that day, or next day? And no, yeah. What did you do immediately after that? Well, that's a matter of a court order. And then, approach, Your Honor. The attorneys are sleeping at the wheel, and or they're not sleeping at the wheel, and they say, may we approach, Your Honor? Your Honor, I think the next thing in order, the next thing you did was the polygraph, and you've excluded that. And then judge handles it from there. But it happens all the time.
Okay, so Catastrophe was saying that the Pelley case claims that the trial court made 3 erroneous evidentiary rulings. One was admitting the hearsay statements regarding 404, which was the activities he was permitted to attend. And then I missed her second statement, unfortunately, because now it's too far up for me to grab it. So I know you were pulling up the Pelley case, but Catastrophe was letting us know that.
Oh, good. Okay.
And then Scarlett had a question for you. She would like to hear your take on the RA declining the court-appointed counsel at the very beginning of the case, around the same time as the safekeeping order. That was back when he said that he was going to get his own private attorney. And then they did the safekeeping order with nobody there and just signed off on it and sent him away. And then he had to write to the judge and throw himself, quote unquote, on the mercy of the court to get.
Oh, that's really good, Scarlett. So like all things that involve deep, serious legal analysis, Michael Ausbrook raised this, brought it up weeks ago when I was asking about something in another chat, and he said, well, that safekeeping thing, that's a critical stage, or if it's found to be a critical stage, and he didn't have counsel, they could determine that all statements he made while in prison would be fruit of the poisonous tree and subject to exclusion. Anywho, I didn't realize so he declined court-appointed counsel at the beginning, around the same time as the safe keep order, and then I remember he wrote the letter to the judge. So that puts a little bit different spin on it, Scarlet Letter, in that the exact timing of declining the counsel. So here's the thing. If it's a critical stage, you can't waive counsel, or the judge can't proceed in the criminal, or can't proceed in that critical stage, whether it's a lineup, whether it's an interview after you've been arrested. You can't waive your rights if it's a critical stage. You cannot waive counsel if it's a critical stage. But it'd be very, very interesting to see the timing on that. That might point in the direction that proceeding to a safekeeping or allowing an ex parte safekeeping motion to be presented by the sheriff and considered and ruled on by the judge was more maybe nefarious than originally thought, depending on the timing, or less so depending on where that happened in time. But if it is a critical stage, then it wouldn't matter that he initially waived appointed counsel because he thought he was going to be able to hire counsel. But that's an excellent question.
Okay, so is it okay that, like, legally, that he had no representation at the time that the state was putting him in safekeeping? Because, I mean, would attorneys have, if he'd had attorneys, they could have argued against it at the time, but...
Oh, yeah. So Michael's unaware. I asked him if because he has such a great command of cases on specific appellate issues. He's not aware of, right offhand, any court anywhere, especially in Indiana, ruling that this type of a safekeeping hearing has been ruled by a court to be a, quote, critical stage, unquote. But he said, he hadn't researched it, so he didn't know. And even if there isn't a case directly on point, I may have said this, not him, but it doesn't matter if it's a type of thing where most states appoint counsel. You're not going to have an appellate court issue that it's a critical stage. In Texas, they don't allow incompetency hearings unless the person who's clearly incompetent has counsel. And not only that, only a jury can determine it. And then it's not until that they, and I mean, it's a real quick process. They just pick up jurors literally off the street or in the halls, and it's mostly attorneys, and they put it on, and then if found incompetent, they're sent off to ASH, and then they're made competent. So the fact that there's not a lot of cases out there doesn't mean anything one way or the other. And so that's just unknown at this point, but there's a lot of Sleuthy and others have Ange over at R&M have found statutes related to the process, and it sure walks like a duck, and the duck being a critical stage, talks like a duck, walks like a duck, sure looks like a duck, like a critical stage with all of this other stuff. So these statutes and and whatnot. But they we thought in the motion for certification that was one of the things that they were specifically asking for, but then in the conclusion, like I was saying yesterday, it didn't look as clear as what we had hoped, but now it's already been ruled on. So, that ship sailed. And when we get to what's next, I can talk about what the options would be at that point. But no, I agree with you. It's on this thing that you've got highlighted. It's very hard to figure out how she can even exclude Odinism and ritual killing when those were things that were raised by the state's investigators, as was excluding evidence of the state's people that did the geolocation and the geofencing. So very interesting.
Yeah, let me see if there was, I think there was another one. Question for Travis. Can you follow up with what you learned reviewing Gold's old cases? Is this a pattern for her acting this way?
Oh, Hammy. Okay, so way back in October, when we were going into October, I went back, looked at a few of her cases, and found one that I think a lot of people were familiar with, where she'd been reversed by the Indiana Supreme Court for denying a lawyer a motion for continuance based on the state not turning over stuff until just a couple of days before trial or the day of trial. And the attorney laid out a very good explanation for the need for the first he moved to exclude it, overruled. In light of the court's ruling, I need time to get my own expert to address this. No, you don't need it. Lays out proper record, goes up to the Indiana Court of Appeals. They agree with Judge Gold, and then it goes to Indiana Supreme Court and gets reversed. Then as we were going into the oral arguments on the second original action, I dug into every case that she ever decided, and that had been reversed either by the Indiana Court of Appeals or the Indiana Supreme Court. And she had been on the bench, I believe, 12 years and had been reversed. There were 8. There were 9 decisions where she was reversed, which it's hard to judge whether that's high or low. I mean, I know lots of judges never been reversed, but she'd been reversed a number of times. The one case where that lawyer asked that the evidence, and it was the alleged sexual molestation of a child, I want to say between 8 and 12 years of age, and I believe was the daughter of the defendant. So, I mean, tough case, and inexcusable for the state to be offering this stuff last minute. But she wouldn't allow the wouldn't strike it, wouldn't allow the continuance. But then there's this appellate court, 3-judge appellate court said, yeah, that's cool. And then, finally had to go to the Supreme Court. And so I was looking at it from a different angle. How, what kind of a shot is the Indiana Supreme Court going to give the lawyers for Richard Allen in the original action? But that's kind of the same pattern, a specific instance, but it's and then I found the case. It wasn't an appellate case about certification, where she granted the new lawyers that came in after she removed the lawyer that the original lawyer in a death penalty case. The new lawyers asserted that she had denied the defendant his choice of counsel, and she approved it, and it was going to the Indiana Court of Appeals, but it never went anywhere because the state offered to take off the death penalty in exchange for a plea of guilty, and so that one went away. And then, it's really, really difficult to pick up from appellate court decisions, because they tend to sanitize things that may be unflattering to the judge, unflattering to the prosecutor, even unflattering to the defense attorney, if they're not part of an issue in the case. That there just was a blow up or a heated exchange, and it would be part of the case if it was comments throughout the trial about the attorneys or the defendants. That would be bias, but outside of that, they tend to clean everybody up and or don't focus on that, so you really don't get a flavor for how things proceed. I'm sorry I don't have a better answer to that question. Really, that's a question for somebody from Allen County that is there all the time. Of course, they're probably not going to want to talk about it. They're not going to want to make the judge mad, but maybe somebody that used to be there or was a defense attorney and now the prosecutor's office, they're not really going to want to talk about it either. But that would be about the only way to find out what her reputation is for how she conducts things in pretrial hearing. But the fact that just in this case, you don't even have to look much further. So she's kind of going off on her own on how she's going to treat the confidentiality of what are normally public court records in the case, which she laid at the feet of the clerk. And clerks just don't make those kind of calls on their own. And then her making determinations that filing a notice of claim based on the treatment Richard Allen was receiving while in prison, and the court said that was part of her list in the in-counsel, in-court, in-camera hearing in her chambers. They, she had this laundry list of things that she had written down that showed that Baldwin and Rosie were not competent, were ineffective, et cetera, and one of them was that Rosie had filed a notice of claim. And at the time in October, I was saying, when the transcript came out, I just said, that's bizarre. That's not true. I mean, that happens all the time. It would be unethical for his attorney not to preserve any potential claims based on the way he's being treated. So she's got a different view of things and history of it, but that's about all I can say.
Okay, so let me ask you about another judge then. So a couple people actually had a question about Diener yesterday, and I was unable to kind of fit it into what we were talking about. But Thomas brought it up again today. So essentially with Judge Diener, now, he's not even a judge anymore. He's stepped away. Is there a way to depose him? Like Thomas is saying, can Diener be questioned about the search warrant that was ordered or the fact that he was the judge? I mean, can he be talked to at all?
They can reach out and talk to him. Anybody can, but the judge isn't a witness in a motion to suppress based upon a search warrant affidavit. And the case that says that is Frank's. The only thing you look at is the four corners of the search warrant affidavit. And so his testimony would be pretty much irrelevant as to what's in what his interpretation of the search warrant affidavit was, that it's solely within the providence of the trial judge as to whether there was enough in that warrant to support probable cause for issuing a warrant. What the judge says about it after the fact would never be looked at. Now, that's on that issue. I don't know if there's other issues. Let's say how did this thing go down with the sheriff presenting you with a safekeeping order? You really don't get the courts looking at stuff after the fact. They don't go to the original judge and say, what the hell were you thinking? Because it doesn't matter. If they thought it was important enough as to what they were thinking, it would be in the order or an opinion. They don't get to come back in and explain. If it was error for them to do that, it was error. It's an objective analysis, not subjective, meaning it doesn't matter if you did it in good faith, that you thought you were doing the right thing. What matters is, what did you actually do? But they can talk to him, try to, and then he may say, I don't think it's appropriate while it's pending, but if either side tried to serve him with a subpoena to give a deposition, it'd be quashed quite quickly if he didn't want to give the depo, which I'm sure he wouldn't.
So your thought process is that really he wouldn't have anything to offer, even with the fact that he says like one of the reasons he doesn't want to be on the case is because of the bloodlust, and that he's signing these orders without an attorney present. Like, do you think any of that would be important, or at this point it doesn't really matter because, like you said, it's already done and they'd have to file it?
I know for some this concept's going to be really, really difficult. It's not done, and the reason why it's not done is it doesn't matter what he's thinking. Now, if the theory is that he did certain things because he was paid a lot of cash, I mean, if you really have the goods on that, then yeah, but you'd be presenting that at pretrial hearings, and you better have the goods on that. But if you did, and it wouldn't be the first time that it happened, if you had evidence of illegal conduct, and when I mean illegal, criminal conduct, not making bad decisions ruling that searches are legal when they were illegal, but committing criminal conduct, trading sexual favors with prosecutors, or having undisclosed sexual relationships, extramarital affairs with prosecutors that weren't disclosed during the trial, then judges have been brought into a grand jury to give testimony. It's part of a criminal proceeding, but we're talking two completely different planets. We're talking two different universes. And so, no, you don't talk to the judge that signed a search warrant earlier on in the case. It's usually a magistrate anyway, the same person that hears traffic tickets. Class C, an Article 3 judge can be any neutral and detached magistrate. And so on a motion to suppress, and to determine whether a search warrant was valid or anything related, it's the trial judge is looking at that. It's usually almost always another judge that does it. No, they never bring in the judge to find out what were you thinking, or what the hell happened here, outside of some serious criminal misconduct that the judge in question is suspected of doing. And they're not going to let you go on a fishing expedition either before that question comes up. Well, why can't you talk to them to find out? They just don't do that.
Okay, so do you want to touch on the two cases from the motion in limine before we go into Perlmutter?
Well, sure.
Sure. You want to talk Allen versus State first? Because I know that both sides talk about this case. And then
let's start with Allen, because it's got some really good, juicy language. And let me pull up my copy, and I'll kind of direct you where you can go, and I'll let you know what page it's on. And
okay.
So again, I just pulled this one up because it was one of the most recent cases cited by the defendants in their brief. And this is Court of Appeals of Indiana. I'm on the first page, upper left-hand corner in the caption. Decided in August of 2004, so almost 20 years old. Transfer denied there means that they tried to appeal. The state tried to appeal the decision to the Indiana Supreme Court, and the Indiana Supreme Court has discretionary jurisdiction. That means briefs are sent up by the losing side, and they say, hey, this is an important issue and you should hear it. It's up to them whether they think it's important or not, and they did not think it was important. And then down to the bottom right-hand corner, facts. There's a murder, and 2 people are found dead at a Osco drugstore in South Bend, and stole cash, a whopping $5,400. I'm down to the next page. Bunch of facts about the safe. I'm now on the 3rd page, and I'm going to skip down to okay, it's page 8 of 16, exclusion of evidence.
Where are we at on that one?
Are you there? Roman numeral 2.
On page 3, or did we pass that?
I'm sorry, page 8 of 16. 8, okay. Page 8.
Okay, here we are. Exclusion of evidence. Gotcha.
So Allen next claims that the trial court erred in excluding evidence that was favorable to his defense. Specifically, Allen maintains Bethel's testimony that Crenshaw and other individuals had actually committed the crimes should have been admitted at trial. That the exclusion of Fred McGill's testimony, indicating that he saw, never get that name, alive at the time the state asserted she was already deceased, was error, and that the reconstructive and experimental evidence offered by William Lumpkin regarding Rannell's testimony placing Allen in some proximity to Osco is improperly excluded. And then they talk about where this stuff comes from. It's the Due Process Clause, the 14th Amendment, also compulsory process and confrontation clauses, which is the 6th Amendment, which is why attorneys get confused. And then at the bottom of that column, it says a meaningful, in resolving these issues, we note whether rooted directly in the Due Process Clause, the 14th, or in the compulsory process or confrontation clauses of the 6th. We don't care if it's the 14th or which part of the 6th. The Constitution guarantees criminal defendants a meaningful opportunity to prevent a defense. Quoting the Indiana case of Kubish versus State from 2003, quoting my case, Crane v. Kentucky, 1986. This is the one I mentioned yesterday. And then this quote, the right to offer the testimony of witnesses and to compel their attendance if necessary is in plain terms the right to present a defense, the right to present the defendant's version of the facts, as well as the prosecution's to the jury so it may decide where the truth lies. Just as an accused has the right to confront the prosecution's witnesses for the purposes of challenging their testimony, he has the right to present his own witnesses to establish a defense. This right is a fundamental element of the due process of law. And then down to page 9, exclusion of Bethel's testimony. I'm sorry I didn't have more time to.
No, you're fine. I'm good. I'm highlighting it as we go.
Marking it up. I don't know. Okay, so here's the 804 thing. So on that page, exclusion of Bethel's testimony, below that, in accordance with Indiana evidence, are you there?
Right here. Yep.
In accordance with Indiana Evidence Rule 802, an out-of-court statement offered to prove the truth of matter asserted is typically not admitted into evidence. However, in accordance with Indiana Evidence Rule 804b2, such testimony is admissible as an exception to the hearsay rule if the declarant is unavailable. And then they get into whether this would have been admissible or not, inadmissible. Fact is, the U.S. Supreme Court in other cases have said that, if it's good, solid evidence, the state rules of evidence are going to have to give way at sometimes. But now I'm down to page 10, McGill's testimony. And so there was another witness who had information, according to the defendant, that showed the potential for somebody else committing the crime. And on this one, McGill, it was people pointing, saying that somebody else was actually the real perpetrator. Then at the bottom on page 11, left-hand column, at the very last sentence in that left column, under these circumstances, are you there?
Yep.
We cannot say that the exclusion of the McGill evidence was error. So that's on him. And then going back up to this other witness. So we're going back up to page 10. Sorry.
You're okay.
So right above B, McGill's testimony, that paragraph, under these circumstances. So let's go even one above. So in our view, the record supports a conclusion that Bethel's testimony was exculpatory, unique, and critical to Allen's defense. There was no other source for Allen to rely upon to present this part of his defense, that another individual had committed the crimes. Under these circumstances, we must conclude that Allen had the right to present evidence that Crenshaw was involved in the commission of the crimes. Such evidence goes to the very heart of this fundamental right, and the trial court's exclusion of Bethel's testimony made outside the presence of the jury impinged upon Allen's right to present a complete defense. Hence, we reverse Allen's convictions on this basis. So remember the court's order granting paragraph 7 of the state's motion in limine at the very end. She said the defense will be able to call those witnesses, or will be able to make offers of proof. Didn't even say could call the witnesses. Well, that's what happened here. The judge allowed him to call the defendant to call Bethel and give testimony outside the presence of the jury to make an offer of proof, but does no good if the jury isn't allowed to hear it. They make their decision obviously unaware of what the testimony was. And then we're going to go down to 11, exclusion of reconstruction evidence testimony. So they're looking at stuff from the crime scene and different things. And I'm now to 12. And on the left-hand side, says, in these circumstances, page 12, left column, almost to the bottom. In these circumstances, it is apparent that Lumpkin's testimony, the tests he conducted, and the video he prepared were based on particular evidence in the case. Specifically, Lumpkin used the prior testimony and statements that Rannells had made to law enforcement personnel to create the video. In essence, Allen sought to admit expert evidence based on factors that Lumpkin knew, all of which were based upon the statements and prior testimony. The problem was all was good with the evidence, but counsel, that's this next paragraph, that said, you always hate when you see that in an opinion. The situation here is quite unlike those cases where random hypothetical questions were posed to a witness, none of which were based upon facts and evidence. Unfortunately, in this case, I think the court ruled, wait a minute, that's what the state was arguing. And so we had an expert that did a good job. It was based on evidence in the case. And then still on page 12, right-hand column, the very bottom paragraph, like the circumstances regarding the exclusion of Bethel's testimony, it is apparent that Lumpkin's testimony was critical to Allen's defense in establishing he could not have been the driver of the vehicle, she observed. So they're talking about a witness who positively identified the defendant as being the driver of a vehicle. Which I may have gotten that wrong. They're talking about this as a witness's ability to either see it was Bethel or not Bethel. Lumpkin's the expert. I don't have time to figure out which way it goes. But the court ended up saying the trial court abused its discretion. That's rare for a finding of that, and excluding the admissibility of the tests and Lumpkin's testimony regarding the results of those tests. This would be akin to shooting a cocktail glass out of an air cannon in Karen Reed. Such was the type of evidence that prevented, we're now at top of 13 left, Allen from presenting a meaningful opportunity to present a complete defense. So he wanted to present a witness who was going to testify that, other people have pointed to this other individual named Crenshaw is the real killer. He hired an expert to either corroborate or dispute a witness that created an alibi for the defendant, and denied both. As a result, we also reversed based on this process. Let me just do a quick word search in here for nexus or direct.
Okay.
And then we'll go to the other case.
So ultimately, this case ends up being overturned because the judge would not allow testimony from a witness and testimony from an expert, essentially saying that the defendant was not the perpetrator. And so it's overturned so that stating that his due process rights were violated because he did not have the right to present his defense.
Opportunity to present his defense, exactly.
Okay, and doing so, and then his defense team was essentially arguing we can't give you more of a connection between these things because I just looked. Direct connection or nexus wasn't involved in that case at all. At all. So it wasn't denied based on there not being a nexus. Do we know what it was? Why did she deny it, or he? It was reversed because. But why did the judge initially deny this expert and this witness being able to come in? Yeah, because the state argued it was inadmissible under the rules of evidence. And the judge agreed. Yeah. And then it was overturned. Yes. Okay. Now, remember, that's an 04 case. And then,
let's pull up this other one that looks at things from a different perspective. It was cited by the state. So it's, obviously going to be from a different perspective. And I will pull that up and so in this one, I believe there's a whole bunch of discussion. So page 1, Jason Tibs, State of Indiana, Court of Appeals, 2016, doesn't indicate if they tried to take this up in case summary issues. Tibs raises 3 issues, which we restate. They're inside joke when they say which we restate. Whether the trial court abused its discretion by excluding evidence of an alleged third-party perpetrator. So now the court's using a coined term, third-party perpetrator, like third-party culprit in Massachusetts or third-party suspect in many other states. So that issue going to be big. The other 2 issues don't have anything to do with us. So we got to find Roman numeral 1, which is on page 3. Okay. Analysis, exclusion of alleged third-party perpetrator evidence.
Okay, 1 second, Travis. So anybody who's just popping in, we're going over, currently we are talking about a couple of the cases that were cited in the motion in limine, and the defendant's response to the motion in limine. So just kind of giving you guys an idea of what we're talking about and why they were cited and how they connect to the Delphi case. So that's kind of where we're at now. And then we're gonna jump, after we're done with this, we're gonna jump into a review of Don Perlmutter's testimony. So just a heads up, everybody, on why we're talking about this. So paying attention to what was overturned, why it was overturned, and what the defense and the prosecutors were trying to bring forward initially, and how the original judge ruled and sending it to an appellate court to begin with. So that's why we're talking about it, is because this is what the attorneys in the Delphi case are using to say, hey, this is why we want what we want.
Perfect. It's a great recap. So we're there at that paragraph 16, there in brackets underneath issue Roman numeral 1, exclusion of alleged third-party evidence. So the court lays out what Tibs is contending. The trial court denied his right to present a complete defense, which is what was argued in the Allen case that got reversed, by excluding, and this detailed type analysis wasn't done in Allen. Maybe more clear cut, maybe because the law developed more in Indiana in the intervening time period. But here they're laying out what the defense contends denied him a complete defense. 1, testimony that McCarty was indicted for Risen's murder. Risen's the murder victim. And so, holy cow, this may be worth for some people, to review later on. So they not only suspected somebody, they indicted somebody for this same crime. Risen's statement that McCarty threatened to kill her if she disclosed that he sexually abused her. Statements that McCarty asked Lori to clean out his car, and the details of McCarty's inconsistent statements regarding his whereabouts the night Risen disappeared. So not 100%, not, a lot of things are different than this case, but we got some elements of inconsistent statements in the Richard Allen case, like there was with McCarty's inconsistent statements. Don't have the fact that they indicted somebody else, but we do have that they were looking at other people, and they were looking at a specific theory that included particular suspects, i.e. Odinism. So 17, anything you want to mention on that before we go on?
I'm good. Yeah.
So number 17, they're basically just saying what the standard is, the standard of review. And we review trial court's ruling on the exclusion of evidence for an abuse of discretion. It's a difficult standard to meet if you're the person trying to get something overturned. And it says the trial court's ruling regarding the admission of evidence will be upheld if it is sustainable on any legal theory supported by the record, even if the trial court did not use that theory. We will reverse only if the trial court's decision is clearly against the logic and effect of the facts and circumstances. Generally, errors in the exclusion of evidence are disregarded as harmless unless they affect the substantial rights of parties. So if you object that the court excluded something improperly that wasn't so serious, maybe character evidence, didn't go to the heart of the defense, the reviewing court, the appellate court, they won't even look at it. They'll disregard it as harmless error. If you can make enough of a showing that it affected your constitutional right to present a defense, they will look at it, but it's got to be, they got to blow it pretty bad. And then look, we're now next page, right before paragraph 18, and they cite the case that we started with, Allen v. State. But in Allen, they found they found that the exclusion of the expert's testimony was an abuse of discretion. They found that the exclusion of the witness's testimony was a violation of the Constitution, which is, even a step above. 18, evidence which tend to show that someone else committed the crime makes it less probable that the defendant committed the crime and is therefore relevant. That's the definition of relevance. Teresa and I were talking about that before we started. So evidence is relevant if it tends to show that someone else committed the crime or makes it less probable that the defendant committed the crime. That's what the definition of relevance is. And in typical crime, the fact that somebody else did it, it's relevant. Such evidence may be excluded if its probative value is outweighed by unfair prejudice, confusion of the issues, or the potential to mislead the jury. There's that Pelley case again.
Pelley case, yep.
Below that, in the context of a third-party motive evidence.
Before we move on from that statement, I want to touch on the statement real quick, because if its probative value is outweighed by unfair prejudice, confusion of the issues, or the potential to mislead the jury. We've heard this in so many of the documents recently. But
right, and that's it may be quoting Pelley, but it's actually also quoting right there. It explains it's citing Indiana Evidence Rule 403, and so.
But there's no who's determining the probative value being weighed or outweighed by unfair prejudice. Like that's where I think people are.
That's a balancing test that's done by the trial court judge.
So she has the discretion to say, no, I believe what you have presented to me so far is more prejudice and would create more unfair prejudice than it has any type of probative value.
Right. And they've actually left out part here, which is why younger lawyers get this confused. What the rule actually says is substantially outweighed by unfair prejudice. It doesn't say it's outweighed. Substantially outweighed by unfair prejudice. So even they've screwed it up here. But it's a common thing. But the rule requires substantial, that the probative value be outweighed, is substantially outweighed by unfair prejudice, confusion, or misleading the jury. No, the court makes that determination based on the pleadings, the evidence that you hear. Typically, you don't even get a hearing to put it on. It's done on the fly in the middle of the trial, and both sides present their case. If there's enough of the question for the judge where they're kind of leaning, maybe granting the motion, they'll excuse the jury and put the witness on, listen to everything, and then wait until they have all of the information before trying to determine whether relevant evidence is substantially outweighed by unfair prejudice or confusion, misleading a jury.
Okay, so Catastrophe asked, can you give an example of like how would a judge go about determining that this information when it, like, make it an example relevant to like the Delphi case?
How they do it is you base it on your knowledge of the law and that the cases that are cited to you by counsel that are directly on point. If there's none directly on point, that are similar from Indiana, as similar as possible, and then if there's nothing good there, then you go outside, go to federal court cases in the Seventh Circuit, and then state decisions. But both sides provide cases they think are similar, and you argue back and forth why a particular case is controlling or not controlling, and that's how it's typically done. I don't know how this court does anything. So
from what you've heard, so I'll just ask you then straight out then, from what you heard in the testimonies and the notes of the people who were there that for the testimony we don't actually have transcripts for, do you think that there was enough shown to make its probative value bigger than its prejudice? Or would you agree with her saying?
No, I think no, I don't think that was shown at all. I think, and what we're going to get into later here, is despite this law, that there's other law in Indiana that talks about this direct connection. And from what I heard of the testimony that we do have, there wasn't enough. But on third party perpetrator, but there was plenty enough on Odinism and that related stuff in terms of being able to show a biased investigation, an incompetent investigation. There was more than enough. And there was zero evidence that that would be prejudicial, that it substantially outweighed by unfair prejudice, because it's not prejudicial. It's things aren't prejudicial because they hurt your case. Things are prejudicial if you're entitled to present a defense and you're precluded from doing so. That's prejudicial.
So give me an example then of how them being, if the defense was able to introduce, like kind of like catastrophe, saying like an argument for it and an argument against it. If the defense is able to present third party, we'll just go with motive, take the people out of it. Third party motive that is not connected to the defendant, how is that considered unfair prejudice versus its probative value?
That's the next line. In the context of third-party motive evidence, these rules are grounded in the widely accepted principle that before evidence, and then they switch back to a third party, is admissible, the defendant must show some connection between the third party and the crime. And this is what I was trying to explain yesterday. There's none of these cases talk about motive. Maybe Pelley does, but they're not talking about motive in the way that courts in other states use motive where the third party comes in. But let me give you an example of where the probative value of something might be substantially outweighed by unfair prejudice. And here's a classic one that comes up a lot. Typically, every town, more so now, but in the 80s or 90s, like even in Austin, typically every city will have a bar that caters to people who are not heterosexual. They may be lesbian or gay. And back in a certain period of time, the fact that let's say they get pulled over for a DWI, the fact that they were when they're pulled over, as is fair, that where are you coming from, where are you going, that's relevant as part of the investigation for the prosecutor, that coming from a bar admitted to having 2 beers. And then if the driver of the vehicle happened to say the name of the bar, and everybody in town knows that that is a bar that's frequented by gay men or lesbian women, defense counsel would make a motion in limine to limit, to rule out that the name of the bar, because it has nothing to do with the crime alleged. It's only being offered to get the jury to dislike the defendant and get the defendant found guilty because of their sexual identity or sexual preference or their lifestyle, not whether they committed the crime. So that's a classic example of whereas if it was a driver that was at the local college watering hole that everybody goes to, there's no stigma attached to it. The fact that, I came from Al's bar, that's where I was. I had 2 beers there. No one would argue that that's not relevant, and no one would argue that Al's bar, knowing that, is prejudicial and outweighs its probative effect. But you flip it to where people would judge you for potentially, and again, it's a good while back, but that's the best example I can think of off the top of my head.
Okay. All right, we'll keep going. Catastrophe said Pelley's third-party motive evidence shows that the police investigation failed to follow all possible leads, and therefore the state did not prove his guilt beyond a reasonable doubt.
Yeah, we're gonna have to pull up Pelley,
Okay.
but at some point, and to get to the answers that you're asking, and frankly, this should have been laid out in the briefs by somebody, going, not just giving citations of cases with bare summaries the way that it was done. If you think there are good cases going for you, you list them out and you say in Jones, in the brief, in Jones, yada 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 yada, here's all of the things that are similar. This is right on point. And rejecting that evidence is reversible error. I got to grab a glass of water, and I got to do something with this dog that's yiping. But you can look at paragraph 21, and I highlighted the start in Pelley and highlighted all the way down to pretty much the up to the last sentence of that talks about what they thought was important about Pelley. And then I'll be right back.
Okay, I'm going to try to pull up Pelley too. So this is in Pelley, our Supreme Court rejected the argument that the trial court denied the appellant his right to present a defense when it excluded evidence that a third party had a motive to commit the murders for which Pelley was convicted. So Pelley was convicted of murdering his father, stepmother, and 2 sisters. He sought to introduce evidence that his father may have been killed because someone learned about money laundering at the Florida bank where Pelley's father previously worked. And Pelley offered statements related to money missing from the bank and the family's subsequent move to Indiana. The fact that the DEA closed the bank and that a neighbor had seen a limousine with Florida license plates in the area of the Pelley's home the night of the murders. Okay, let me see if I'm trying to pull up Pelley. Okay. Go ahead, Trav.
Okay. So they talk about 19 in Joyner. Our Supreme Court back in 97 concluded the trial court abused its discretion by excluding Joyner's proffered evidence that a third party committed the murder for which Joyner was convicted. He wanted to introduce evidence, guard third party. He had an affair with the victim. He worked in the suspect, third party perpetrator, had an affair with the victim. He worked in the same place as the appellant, saw the victim the day before the murder, lied to his wife about where he was the night of the murder, later told her he had an argument with the victim, went to work late the day after the victim disappeared and lied about his tardiness on his time card. And then Joyner's evidence included expert testimony that a hair found inside the plastic bag covering the victim's head excluded Joyner as the donor of the hair and indicated that there was a 98 to 99% probability match with respect to the third party. I mean, it's unbelievable how that could have been excluded. But the point is, so there's a case where, I mean, it's like, how on earth could the trial judge have excluded the defendant, Joyner's request to bring in this evidence about the third party suspect, given all of that forensic evidence plus. And then they talk about Lashbrook, our Supreme Court rejected, is paragraph 20, an argument similar to that made in Joyner. Want to introduce evidence, third party stated the victim was going to die. Our court concluded, in stark contrast to Joyner, the defendant presents no material evidence that the third party was connected to the crime. The phrase allegedly uttered by the third party that the victim was going to die does not tend to show that the third party committed the murder. So they're offering cases from opposite ends of the spectrum, and then there's going to be 1,000 shades of gray. And it's literally, to know this issue, one would have to read every single case on this issue from Indiana and find the ones that line up and find the ones that don't. We're never going to know what the court did because it doesn't explain. Then paragraph 24, there's our case we started with, Allen v. State. Court reversed a murder conviction because Allen had the right to present evidence that a third party was involved in the commission of the crimes. In that case, the trial court excluded testimony that the witness and a third party cased the Osco drugstore where the murders took place. The witness encountered the third party coming from the direction of the Osco drugstore. Third party told the witness he had just got some money and some people got hurt and got killed in it. Third party showed the witness a handgun similar to the one used in the murders and told the witness it was dirty, meaning it had a body attached to it, or bodies. The record, this court concluded a conclusion that witness's testimony was exculpatory, unique, and critical to his defense. So what I'm trying to point out here, T, is that it's a deep, deep dive into looking at third-party perpetrators. And we're not talking about, and I'm not even going to call it motive evidence. It's bias evidence about the Odinism and whatever else was described. And it's not third-party motive evidence at all. It's it's evidence like they used in Karen Reed, and which is why we still don't know exactly what's going to happen if they start on cross-examination getting into tunnel vision of the investigators, that they were aware of, even if they don't use the name Odinism, that there's traits of particular groups associated with the crime scene that they didn't follow up on. I think the court thinks it's out. If I was the state, I was going to say, oh, you were clear in your order. None of this stuff's coming in. But arguing, this third party motive stuff isn't what But, we kind of predicted this, and you'll remember, Teresa, over and over and over, I'd say in chat, or if I was with you talking about the thing, I always said, I don't think they're going to be putting Odinism in for the, reason people think they are. I don't think the defense is going to offer Odinism and try and say, she was killed by Odinists. I think they're going to be using it for bias. And, after you do this long enough and practice at it, I'm still practicing at it, but, you kind of just get a feel for how these rules of evidence and these rulings work and all this stuff fits together. I didn't have very much confidence that they were ever going to allow what they had to point to somebody, or that a particular person, and this is going to tie into Perlmutter, or that the person was a member of this organization, religion, that textbook case, all of the whatever. I did think they'd have no problem whatsoever being able to show and buttress it with experts that you guys messed up. There's all these clues that you had that you acknowledged you had, and you didn't follow up on them. So we're where we're at.
Sorry, I got interrupted by a husband.
Top priority. Husbands are number one.
Yeah, kids are number one. Husband ranks number two compared to them.
That's true, I think. No, we, I've been saying, I don't think they're going to be doing it, but sure enough, they did and got an expert to do it. But now it looks like they're in a bit of a bind. So to me, I don't think they have any choice but to clarify that they can still get into the things they want to get into about the investigation and things not being pursued or bias and those sort of things. But it's really difficult to show a direct connection in the states that use that terminology, nexus, those states. They just cited two quick examples there about what Joyner had in his case, what Allen had in that case, and then the one where they had everything Joyner. So that's what I wanted to bring out in Tibs.
Okay. So I pulled up Pelley, but I haven't obviously had a chance to look at it. And I think we covered a lot of what was important from it, just from the other.
Just do control find and put motive, and we'll find out what this thing's about. Admission of certain hearsay statements and exclusion of evidence regarding third-party motive, and the prosecutor's delay of bringing charges. So go to the next instance of motive. State's evidence against Pelley is entirely circumstantial. The state's evidence of motive was inconsistent statements given by Pelley and his father leading up to the prom about what activities Pelley could attend. Scroll down.
Oh, you want me to scroll down or go to the next motive? Sorry.
Scroll down. Okay, that's the end of it. Go back up. Okay, no, down the page below. Okay, stop. I'm just trying to get what we need to get a sense of where the motive is. So we know that the kid's going to prom. He's being told what he can do, what he can't do. So I'm guessing he's killing a parent. On the day of the prom, 29th, Jeff worked the early morning shift at McDonald's, washed his car, watched a baseball game. Others noticed lack of movement at the Pelley home. I'm over on the right-hand side of that page. One of the Pelley's neighbors was mowing the lawn and noticed the Pelley's lights were off. None of the girls were playing outside. Okay, scroll down. Okay, let's just go to next mention of motive.
Okay.
State presented sufficient evidence from which the jury could conclude beyond a reasonable doubt Jeff committed the 4 murders. Evidence of motive, access to a weapon of the type used, and presence at the site were all established. That's weird. Indiana require evidence of motive for murder. That'd be the only state in the country that does that. Now they can prove motive if they want. But it's interesting. They're talking about the state putting on evidence of motive. I don't know if the part to the right is the next mention. Go to number 4 of 13. Next motive.
Next motive. Okay. Yeah, that's the next one.
Yeah. So he said they admitted hearsay statements regarding which prom activities he was permitted to attend, excluded testimony showing a third-party motive. So go down to B. A is hearsay regarding prom. We don't care about that. Let's go to B. B, exclusion of testimony regarding third-party motive. Pelley argues the trial court erred in excluding evidence that a third party had a motive for the murders. Pelley asserts that the exclusion violated his Sixth Amendment right to present a complete defense. Pelley also contends that the third-party motive evidence shows that the police investigation failed to follow all possible leads, and therefore the state did not prove his guilt beyond a reasonable doubt. Damn, the hits just keep on coming. This is bad. So third-party motive in Indiana is what I call, and everybody else calls, bias in other states, which is fine. I mean, courts can call things differently, culprits, perpetrators, suspects. Now, I don't know if under Indiana law that's this evidence about that the police investigation failed to follow all possible leads. If that's always considered third-party motive, or if you can also bring it on more traditional grounds like, we do in Texas, or that they did in the Karen Reed case, that it's under bias, why it's admissible. So let's
Isn't that exactly where we're falling at with Delphi, though, is the lack of follow-up of the investigation on these particular third-party perpetrators?
It is. That's why I'm saying this is not looking good, because they made the basis of the state's motion was third-party motive and third-party perpetrator. And third-party motive can include evidence that shows police investigation failed to follow all possible leads. And the one thing I don't know is if that's the exclusive way they call it, or if you can do it under bias. But evidence of third-party motive tends to make it less probable that the defendant committed the crime, is therefore relevant. So that's relevance. Go back up, scroll to the top on the right-hand side, see if there's anything. Nope. Okay, go back down. In the context of third-party motive evidence, these rules are grounded in the widely accepted principle that before evidence of a third party is admissible, the defendant must show some connection between the third party and the crime. Yeah, that's true, but that evidence that you highlighted over there on the left-hand column failed to follow all possible leads. You can bring that in just in all states that I'm aware of, including Massachusetts, where Judge Cannoni ruled third-party culprit is out for now. And they brought in all of that stuff about, so you didn't try and talk to the property owner, the owner of a home that had a dead body in the front yard, didn't bother to try and interview the owner of a home. Not only was it a dead body, it was a dead Boston police officer. You guys remember all those questions,
Right.
Those are biased. They have nothing to do with third-party motive. So not really, but this is not looking good, and it's looking like they need to file a motion to clarify, Teresa, just on the fact that, yeah, okay, we get it. We disagree, we respectfully disagree, but we understand. But that wasn't the only basis that we were offering the testimony of Perlmutter and to get into how they botched the investigation. We were offering that under the bias rule or this case, separate and apart from third-party motive. You see what I'm saying?
Right. Or do they just go into trial and just do it?
Well, kind of talked about that yesterday as strategy, but I think you bring a motion to clarify, and then hopefully the court says, well, no, I thought it was self-explanatory. Anybody knows you can always bring that up in a defense. I would never try and exclude that. And then, yeah, you go to trial and do your best. But, if she said, well, of course, it's out for all purposes, you're not getting anywhere near that stuff. Then that then becomes part of the court's decision granting the state's motion in limine, and then you file an original action based on that. That would be my strategy. Go to next motive, see if there's any more tidbits. Anything else is going to make my stomach settle. Nope. Next one.
Okay, so we got the relevant to Jeff's motive.
Nope. That was it. I think. No, weren't we just there?
I guess.
No, I took you there on my own. Okay.
Yeah, you did. Thank you.
Under these circumstances, we determined that the defendant had sufficiently connected the third party. Go up and let's see what they're citing there. They keep saying id. Go up until there's a citation in that left-hand column.
Mr. Ausbrook's in the house.
Michael, can we send you a link? We need Michael in here. You want me to go? You wanted me to go to the bottom of the left? No, I just wanted to see what they were citing. Okay, never mind. I'm not going to go up another page to see what they're citing. Michael could. It's Joyner. Okay. Michael is so much better at explaining this stuff and his knowledge of how this is going to work infinitely superior than mine. All I can tell you is how it works in trial. But, you know, it's got to be laid out. But I'm glad we went through these two cases, because we call it something, like I said earlier, we have third-party suspect law. The state, they can't request notice if that's where you're going, like they can in Wisconsin, but they're able to figure it out early. And so you get faced with these motion in limine all the time on third-party suspect / perpetrator / culprit. And most states are like Texas, Wisconsin, Massachusetts, others, that you have to meet 3 requirements in order to put on a Saudi defense. Some other dude did it. And you got to put on motive of that person, opportunity, and a direct connection. Direct connection meaning you got to put them at the crime scene or put them somewhere that makes that person part of the crime. And so, in other words, you can't get in there and say, well, you know, I think Martians came in and did it. Well, you know, everybody's going to know that's crazy. And then, you know, you start adding more and more and more to it, like forensic evidence. Another family member or another love interest, there's his or her hair is found in a location that there's no reasonable explanation for. Shouldn't be there.
Such as like unknown DNA. And I want to say hi to Michael real quick. So Michael, we've been going over the cases that were referenced in the motion in limine, which is the Allen versus State, Tibs versus State, and now we're currently in the Pelley versus State. So we're just been trying to review to see how they correlate to what the motion in limine was, and how this most likely could end up. And you'd be great to speak on this. How these all essentially say that the trial courts excluded third-party evidence and third-party motive evidence when they shouldn't have.
You know, well, thank you for the welcome.
Thank you.
Hi, Michael. Thank you so much for coming on.
It's nice to be here, and it's you know, nice to parse all this stuff. I know a few things about both Pelley and Tibs. I was involved in Tibs and Fed court. And Pelley was Fran Watson's wrongful conviction case. I think she just lost in state court. For those of you who don't know who Fran Watson is, she just founded the brand new Indiana Innocence Project.
Oh.
And you know, Pelley is a totally preposterous case for Nick McClelland, because the third-party guilt evidence for Pelley was all inadmissible hearsay. None of Brad and Andy's evidence is inadmissible, and it's all direct evidence of a connection to the crime. I mean, this isn't even close. It is so off the wall. It assumes basically Gull is deciding jury questions in this motion in limine. She has to assume, she has to assume, without having had the Holder alibi evidence put in. I mean, you know, you have officers testifying, well, they had alibis. Well, that's not evidence that they had alibis. That's saying our reports show. I mean, it doesn't really work. And it assumes as true the state's timeline, because, and as do the police saying these people have alibis, because if if things happen not on the state's timeline, and I'm saying the state's timeline, they may have not said anything about a timeline, except they've certainly implied one. It's just I can't tell you how bizarre the ruling on the third party evidence is. It is I guarantee you it's a retrial unless the state pulls some rabbit out of their hat. The idea that it isn't reversible error to keep this out, and somebody asked me what Gull's motive is in this, and I have no idea what her motive is. I do know this: she has been a judge too long to make this mistake unintentionally.
I don't disagree with you.
I told everybody we needed an Indiana lawyer. Okay, so let me ask you this first, Michael. So yesterday, Teresa came up on her own and asked, how's this going to work with her ruling? Are they going to be able to get into the bias of the investigators, that they didn't follow up on things, that they didn't do certain things? And then, there was some confusion on my part because I didn't understand the phrase third party motive, but you've come in and explained all of that. But Teresa asked, don't they need to file some sort of a motion explaining? And I said, well, there's a thing for that. We call it a motion to clarify. And well, shouldn't they do that? And I said, well, there's kind of pros and cons of doing that. But what do you think about a motion to clarify, and whether, assuming she just goes right along and says, hey, when I met it, it's out for third party perpetrator, Odinism, and not specific people, but Odinism and
look, specific people. I'm sorry, specific people should be coming in too. We've got confessions by at least, as I count them, 4 people.
Right, but that's my next step. I'm wondering if you file a motion to clarify, saying, well, are we going to be able to bring in evidence about how Odinism relates to what the investigators did or didn't do? And then she said, well, of course, my ruling's clear. It's all out. And then would that help with an original action?
No, I mean, then you're going to have to. No, I mean, they've got enough to file the original action now. I mean, motion to clarify. I mean, this ruling's only preliminary. I certainly hope that they're going to, proceed to trial as if all this stuff is coming in, have all their witnesses and exhibits ready, and
expand on when you say it's only preliminary, because I've been trying to explain to them how normally judges rule on motions in limine. They say, person who's they're trying to keep the evidence out, defendant lawyer, were you going to mention this in your voir dire or your opening? No, I hadn't planned on it, Your Honor. Well, then I'm going to reserve ruling on this. I haven't heard any evidence in the case. It'd be premature for me to rule on it. Mr. Prosecutor, I don't want to hamstring Mr. Williamson when I don't know all of the evidence in the case. You attorneys, the whole case. I don't. So I'm not going to hamstring Mr. Williamson, Mr. Prosecutor. I appreciate where you're at. Mr. Williamson, you put on your case, cross-examination. When you get to the point where you think that you've laid enough of a foundation to get into the evidence of whatever it is, you ask to approach the bench, and then I'll rule on it then. Or if I need more info, I'll excuse the jury and we'll have a hearing.
No, I mean, I think you say first, yeah, we're going to mention it, here's what we're going to talk about. And I mean, they can do it 16 different ways, but.
Right. But the point being
I
that
want,
all she says in her order is, defense, I'll let you, doesn't say call witnesses. We're allowed to call witnesses as a matter of right and do a bill. She said, I'll let the defense put on an offer of proof.
yeah, and you know, the way offers to prove usually work in less complicated cases are, you know, you just say what the witness would testify to, and I'm telling you that I hope they don't do that, because I hope they say, no, you know, telling you, Judge, what the witnesses will say is inadequate. We need to put the witnesses on. And I would do that. So we're going to mention these folks in opening arguments. So, you know, let's have the offer to prove now, right up front.
They're in the questionnaire, those folks. But like you said the other day, that could be taken care of in voir dire. You know, it's not any big thing unless a juror indicates, yeah, I know Brad Holder, this is how I know him, or, you know, take your pick of the names, and it's going to benefit the defense.
No, it's not. Brad Holder, I mean, you know.
No. I'm saying the answer on the questionnaire benefits the defense. The state would want to inquire more about it, right? I mean,
I mean, I think I think it could, you know, having somebody on the jury who knows Brad Holder, maybe, and you don't know, maybe bad for one side or the other. If somebody knows Brad Holder, they could think Brad Holder is a very bad dude. Know all about the, you know, accusations about him, and think it's highly likely he was involved. I'm not saying he was, by the way. On the other hand, somebody could know Brad Holder, and, you know, Brad Holder was out doing his whiny weepy thing on one of the deplorables last night, and you know, think that Brad Holder's been terribly abused, and, you know, want to get back at Rick Allen and his lawyers for making the
exactly
the accusation. So you know, look, knowing these people on the questionnaires is, yeah, I mean.
So how is it going to work that the questionnaire, and then we'll get to the easier question about the questionnaire in a second. So the question is, do you know any of the following people? And I know Nick McClellan, I know Brad Holder,
and I know that Brad Holder knows Nick McClellan because they're both Masons in the same lodge.
So.
Well, I think they're actually Masons in two different lodges. That McClellan just got his Master Mason at Brad's lodge. Just FYI, they are both Masons and both have connections to the same lodge. Yes.
Well, depending on who the juror, the potential. People are going to want to follow up. How do you, if there's a limine granted, how do you follow up? I guess you say, Judge, I've got questions about how this juror knows Brad Holder. You want to do it now in front of this panel of 60, or wait and bring them up?
No, right? Look, anybody who knows Brad Holder has to be disqualified for cause.
It's a bad example. Let's go to the question in the questionnaire about, do you know anybody who's an Odinist? And it talks about, are you familiar with that? Do you know anybody who's into that?
And they should be disqualified for cause, because, you know, even if Odinism isn't mentioned, you know, they're going to be asked questions about, well, have you followed this case on the internet, blah blah blah. Anybody who knows an Odinist is going to know there have been accusations of Odinism in this case. So, you know, get rid of them too.
Agree. But so if you're the defense, Nick said, well, Judge, I want a chance to, I don't know if you can transverse the challenge there or not, you know, but I want to inquire, Judge, on behalf of state, I want to inquire more. I don't think it's an automatic disqualification. Then defense says, well, judge, we're getting into Odinism. You've excluded that.
Well, I mean, you've excluded that as evidence. You haven't, that's a different question. But
Right.
I almost guarantee you that I don't even think. Again, somebody who knows something about Odinism, that can cut both ways. I don't think anybody wants somebody who knows something about Odinism on the jury.
I kind of think the defense would. Really, what you want is people who are aware that the stuff's going on in the area.
Yeah, but you don't know what they know about Odinism. You don't know what they think about Odinism. You don't know whether it's like, to me, that's one juror who's it may be a real thing, but that doesn't mean that it's a real thing in this particular killing and ritual killings of human beings. They may think Odinisms are stand-up people. Odinists are stand-up people, and they couldn't possibly have done that.
Well, and I think it has 2 or 3 lines for them to, how are you familiar with it?
Yeah, but you're inviting jurors to lie then. I mean, once they've admitted they know something about Odinism, you want them gone.
Also because of the fact that Odinism itself is just like, do you know anything about Christianity? Like,
I'm just going by the questionnaire, and I assume the defense put these questions in. I don't know, maybe the state did, but so I'm telling you, as a trial lawyer, you send out 600 questionnaires, and your defense is Odinist did it, and you get 600 questionnaires back, and nobody on the planet has heard of Odinism. That's pretty valuable for a trial lawyer. Trust me.
Well,
if 25 come back and say, yeah, I'm familiar with Odinism, and it gives a line to explain more information. Yeah, I'm familiar with Odinism. I'm an Odinist. My brother's an Odinist. My dad's an Odinist. My grandfather's an Odinist. Everyone in my town's an Odinist. This is valuable information, whether they stay on the jury or not.
Well, to me, it's valuable information to get them off.
Well, right, but the fact is, these questionnaires have gone out.
It will never be. It will never be to get them on. If I were, defense lawyers can disagree. I wouldn't want anybody on the jury who said they knew a thing about Odinism.
I could see both sides in that point. I bet they're just, each attorney would probably have their own thought on why it would be good and why it would be bad. But I could see both sides of that.
Yeah,
what I'm saying is
different.
You can't
I haven't run into Odinism, but I've run into racism. And you don't ask somebody, are you racist or are you prejudiced? You know what they're going to say. They're going to give the answer people want to hear. So you do it different ways, and you ask a question in a questionnaire, not a live question in front of the people. Do you know anybody? Do you know anybody who is racist or prejudiced against minorities? And then you get all kinds of questions like, my grandfather was, and he totally disagreed when they integrated college football, for example. And there are parts of Texas where it's very common to get those answers, but you can't ask questions directly because you won't get the info
all I'm saying is that once you have somebody saying they know something about Odinism, that it could be a good person for you, but it's also a possible hand grenade.
I'm going deeper, Michael. I'm going deeper. I mean, the fact is that this stuff's so foreign to me, this Odinist thing. But when I just started looking at the case in October 6th, and then all of a sudden there's this motion and affidavits filed that prison guards in Indiana are wearing Odinist patches. I mean, I don't know. I think I'd want to know if you've got guards wearing Odinist patches. I think I'd want to know a little bit more about it, because I live in a bubble. I live outside of Austin, Texas, which is a political bubble. It's an echo chamber. Like a lot of college towns are echo chambers. The dynamics all across Texas, they vary so much. And it sounds like they do in Indiana too, that, you got to employ techniques about what are the people, this is going to be Allen County jurors, right? Allen, which from what limited research I've done is vastly different. The typical Allen County citizen is completely different than the average Carroll County in terms of political ideology, age, race, everything.
My understanding of Odinism, which is incomplete, the prison part of it is there's some small number of sort of legitimate Norse religion folks. I think the statistic I saw was something like 1,400. And that was from a woman, I think maybe in Arkansas, who is one and actually studies the thing. We're talking about 1,400 some odd people in a country of 337 million. That's sort of what I think she views as the legitimate religious folk. And then Odinism in the prisons becomes a thing because you can claim it's a religion which allows you to be racist and they can't touch you.
Well, the other thing it does, both for guards and prisoners, is despite what the facial hair policy is, you can say, I'm Odinist and it's part of my religion that wear a beard up to 4 inches. And so this is something I have run into. They haven't gone Odinist because there's, a lot of negative connotations with it, but they've gone with something similar and said, it's so that prison guards, and it's more in the prison, but to some extent. And there was a big case out of the Fifth Circuit last year where the Houston sheriff, the county jail, which is huge, tried to say, well, it's a safety matter. You got to be able to wear a gas mask and so on and so forth. And they weren't able to establish it enough. So now if you claim you're an Odinist or other things that are less potentially offensive, you can get around the facial hair policy. But no, it's it may make it safe.
I don't believe you're even allowed to wear a cross into a prison as a CO.
You can't in Texas, which is why it was so astonishing to me that there was an affidavit from defense counsel that, and there was no denial by the warden that these guys were wearing Odinist patches, because there's no case in the country that protects the right of a prison guard to wear a cross, Star of David, patch of Odin. Unless you're a chaplain, you'd be terminated for that if you tried to wear that. And I ask every time there's an Indiana lawyer on a program, I'm like, is that like allowable there, that you can wear patches? It's just mind-boggling to me.
We're getting pretty far afield here. I mean, as far as the evidence goes, I think they've got to just try and put it in, and they got to put it in with their witnesses. And if the jury's there, great.
Yeah,
if the jury's there,
Teresa's going to want to know. Can you explain to Teresa and her listeners how's this third-party perpetrator and this third-party motive? How's this supposed to work?
There's no third-party motive here at the moment that we know of. It's just third-party perpetrator. I mean,
okay, explain what third-party motive is, because she was asking me and I was failing miserably. What's third-party motive?
Well, let me go over here and I'll tell you why I have this question, because it talks about I'm not sharing my screen anymore, so I can't really show you that. Let me share my screen. But in her order, it talks about that they can't talk about Odinism, cult, or ritualistic killing, and then they can't talk about a list of all of these people. So my question was originally, if you remove all of these people, how is there not enough of a nexus between Odinism /cult /ritual when for the first years of the investigation, law enforcement was looking at Odinism or anything related to Norse paganism? How is that not enough of a nexus when it's their own investigation?
So I gotta say that you don't. I mean, yes, the part of the investigation makes it stronger, but Perlmutter's testimony alone is enough, because what you show is she says this, classic signs of a ritual killing, right? Then you tell the jury what we think it's a ritual of, and then you prove that Rick Allen has nothing to do and knows nothing about any of this, and that shows that somebody else did it, even if you don't name any of those people. As I said, I mean, this ruling by Hertz was just not even a close call, and it's almost hilarious. And there was a contempt trial. Everybody calls it a contempt hearing. It was a trial of Brad and Andy, and she actually stepped up to the plate for Nick McClelland with when he was trying to get in Mitch Westerman's, through Holman, get in Mitch Westerman's iCloud account, and offering all this stuff in Mitch Westerman's iCloud account as fact, and it's all hearsay, and Dave Hennessy objected, and McClelland really didn't know what to say, and she said something like, maybe course of investigation, Mr. McClelland, and that's actually not a hearsay exception and hasn't been since about 1999. And so all this, the idea that the stuff from the state's own investigation doesn't come in is, maybe it's like the Karen Reed trial. So the investigation stuff comes in on cross.
Right.
But I mean, it comes in on cross, but they absolutely get to put this stuff in their case in chief. It's ridiculous. I cannot tell you how ridiculous. I just it's so obvious that it comes in. You just can't know what she's thinking.
So then my next question, Michael, then is, if she's already ruled that she's not letting it in, they filed the interlocutory appeal, she's denied that, what do they do now? Do they just walk into trial and just start throwing the questions in, like, hey, this is what we think, and we're going to get it on cross, like you were just mentioning? Or do they file like an original action at this point and say, hey, like, this is a violation of his 6th and 14th Amendments, and we can't proceed, otherwise it is a practice trial, and go that route again? Or is there a third route that I'm not thinking of?
Yeah, there's a third, yeah, I mean, I'd be filing an original action. It's not, I'm not them. I don't know whether the Supreme Court would take it or not. If the Supreme Court were smart, they would, because it will be a second trial. I mean, I guarantee it'll be a second trial. I mean, you just can't do this. I mean, the right to present a defense business. I mean, look, to start with, the cases on the right to present a defense all have to do with evidence that is inadmissible under the state's evidence rules. I mean, that's Chambers v. Mississippi. There's Holmes v. South Carolina. There's a terrific case out of Indiana that the Seventh Circuit decided, Kupch v. Neal, death penalty case. I was talking about this a little bit the other night, where, you know, a long time before the trial, a young girl, child, had given a video statement to the police. But at the time of the trial, of Kupch's trial, she couldn't remember a single damn thing about it. She couldn't remember what, she couldn't remember what she saw. She couldn't authenticate the video. And, the defense if you believe the video, Kupch was absolutely innocent. Because she said she saw him come, right? It was a timeline thing. She saw him come out of his house at X time. Mm-hmm. But she couldn't authenticate it. She couldn't testify to the fact herself at the time. And under the state evidence rules, that video didn't come in. And, the Seventh Circuit said, you have to be kidding. And the oral argument was pretty hilarious. At one moment, then Chief Judge Diane Wood asked the Deputy Attorney General, saying, "So let me get this straight, Mr. X," and I will not use the name to protect the guilty. You're saying the state wants to execute somebody who is innocent if this girl's videotaped interview with the police is accurate. And he really didn't know what to say. But anyway, look, all of this is, Brad and Andy are not claiming, well, we've got all this otherwise inadmissible evidence, which is Pelley and to some extent Tibs. We've got all this inadmissible evidence that shows it's somebody else. Yes, it's not admissible under the evidence rules, but the due process clause and Holmes and Chambers say we get to get it in. That's not this case. This is all admissible evidence. This is direct evidence. I mean, Perlmutter's expert testimony is admissible evidence.
So does Perlmutter, do they use Perlmutter for trial at this point, or does all of that just...
They have to have her ready, and they have to have her... I mean, she testified... Look, I don't know where she lives. My guess is that
Pennsylvania. She teaches at that school of osteopath in Philly.
Oh, and the other thing is, everybody was laughing at her, certain so-called content creators, whom I won't name, laughing at her because they thought that McClelland had made, huge points by saying, asking her, well, have did the defense tell you about the alibis for these other people and various other things? And of course they hadn't. And it's like somebody like Perlmutter, who's looking at the crime scene, doesn't want to know anything else about the case. She just wants to look at the crime scene.
Right.
It's totally irrelevant. I mean, Jim Clemente, the now famous former FBI profiler, when he's doing stuff for Bob Ruff or somebody else, he doesn't. When he's doing a profile, there is a lot about the case he does not want to know about. And the fact that she hadn't been told about a lot of things means that Brad and Andy did not bias her one way or another. I mean, she tells them about Holder. I don't think they even told her about Holder. Tell her about Holder, tell her about these specific Odinists, and that might tilt her one way or another. This is the place where it gets sticky is, so she says they haven't in the denial, she says they haven't provided admissible evidence with a nexus to the thing. Well, that's just not true. But then she gets to 403, which is she can keep out evidence that has the danger of, and she uses the word potential. So she's just copying and pasting from McClelland's draft order if she didn't actually copy and paste it. I haven't looked at the draft order he submitted, because she uses the word potential, but 403, Rule 403 doesn't include the word potential. It talks about the danger of misleading the jury, confusing or misleading the jury. And there's no danger of confusing or misleading the jury. This isn't a sideshow. This is all direct evidence. I mean, I'm as you can tell, I'm practically speechless.
I know.
Go to the part.
Hang on. To go back to the original action question, evidentiary rulings like this are not usually the subject of original action. It's usually got to be something like jurisdiction. At the same time, the Indiana Supreme Court demonstrates over and over and over again it can do whatever the hell it wants, whenever the hell it wants to do it. And one of the prerequisites for an original action is that an appeal is inadequate. Well, yes, a direct appeal after trial is inadequate. They've tried to do the direct appeal beforehand. That was cut off at the pass. So I don't know what's in the works. I will say it again, despite what people continually say all over the internet, I have no direct line coming out from the defense. I feed the defense some stuff, but I get nothing back.
Go to the original motion and paragraph 7, what they asked for, what we started with today. Okay. So, and then, any attempt to introduce evidence, a third-party motive that is not relevant and or the probative value is outweighed. I was saying earlier, Michael, Texas follows the federal rule, and that's a misstatement. It's substantially outweighed by unfair prejudice, but I don't know how Indiana is. Okay, so no evidence.
That's 403.
Okay. So he's misstated that, like a lot of lawyers do, but it's not outweighed by unfair prejudice. It's substantially outweighed. So any attempt to introduce
it's not only substantially outweighed. The prejudice has to be unfair.
I was just pointing out that if the statute or the rule of evidence, federal and in Texas, there's the word substantially in between is and outweighed. But
yeah, and I'm pointing out that additionally the trouble is with unfair prejudice. I mean, look, evidence comes in.
Right.
The whole point of evidence. Yeah. Point
Everything's prejudicial to your case, right? If it's relevant.
Yeah. And so it has to be unfair prejudice that substantially outweighs the probative value.
Got you. So scroll down below, Teresa, where it gets to Odinism, Odinism. It just has the names. Okay. Anything else? Okay. So, and then go back to her ruling. Okay. The court will not permit the evidence submitted by the defense in support. The court will allow that evidence to support an offer of proof at the trial if one is made. And I was saying earlier, Michael, that's about like saying you'd be allowed to inhale and exhale during the course of the trial. It means nothing. And the Allen case.
No, I mean, yeah, that's true, because she really doesn't have a choice about allowing the offer to prove.
Now, in Indiana, in Texas, we can do it either, and it's clear in the statute at the option of the party, which is usually always the defendant making the offer of proof. We can do a bill of particulars, which is nothing more than putting the witness on. The judge swears them in, and we ask the questions we would have asked had they not been excluded. They give the answers, and we are entitled as a matter of right to do it by question and answer method. I guess it's not that way in Indiana.
I suppose that Gall could look. We've got a judge here who has already held a criminal trial inside somebody else's criminal case. We have a judge here who said she would hold people in contempt for not cooperating, hold people in contempt who did not cooperate with the law enforcement investigation of the photograph leaks. She has no power to do that. I mean, she has no power to hold them in contempt. So we have a judge who removed 2 public defenders, and you can argue about whether she had the power to do that. She had the power, perhaps even not to let them in as counsel of choice when they showed up pro bono, but had they not been reinstated in some form or another, that would have been a free trial. She doesn't care about the law, period. And I got to say, I usually say, we're not allowed to say things that bring the judiciary into disrepute. And my answer to that is, yeah, I usually let them do it to themselves. But I don't look. I have already. So I won a case in the 7th Circuit in which the 7th Circuit said that Gull, I mean, it was by implication Gull, because Gull did the same thing before the Indiana Court of Appeals did it. in which Gull made a ruling that because of the standards under which habeas cases are decided, the win meant that her ruling was one that no fair-minded judge could make.
Wow. Really?
Yeah.
Wow.
Well, you don't win under the ADPA, that's the Anti-Terrorism and Effective Death Penalty Act. If a state court decides an issue on the merits, you lose unless the decision was either contrary to or an unreasonable application of clearly established law, federal law, as determined by the United States Supreme Court. And the standard that the Supreme Court has set for that is that no fair-minded jurist would have come to that decision.
And that's what you frequently describe as, in essence, you got to show that the court failed con law, right?
Yeah, basically. Well, there's a second part of it where they can screw up the facts so badly that you can win. And,
right.
No, I mean, that happens. Believe me.
So can I ask you a question, Michael? I asked Travis this earlier, and I'd love to hear your input. But so obviously the rule states like that the probative value has to outweigh its unfair prejudicial value. And so she gets to make this determination on whether the probative value is which one outweighs. Is it unfairly prejudicial or is it more of a probative value? So does she have like a in essence like a scale? Like does she have a way to determine that? Like where does she just come up with? Is it just what she thinks?
Well, and that's the thing. You know, that's why I'm saying she's deciding here a jury question, because she has to assume that a lot of what Nick McClelland has merely said, and you know, maybe some of it's come in from his witnesses at these hearings, she has to assume all that stuff is true. And that's why, I mean, she's just taken a jury question away from somebody. I mean, we're not talking about, this isn't peripheral stuff. This isn't,
Let's go from the other side, Michael. How is a judge supposed to properly do a 403 analysis? Are they act as a gatekeeper? Is it a balancing test? How is a court supposed to do an analysis of whether the evidence, while relevant, the prejudicial effect substantially outweighs whatever?
Yeah, at the trial level, I'm not sure. The way, I mean, I think that's an individual thing. And that's another reason it's not a typical original action thing, because at least, you know, in the appellate context, and an original action is not an appeal, by the way. I mean, it looks like an appeal because it's going to a higher court, but it's really a trial of the judge in the Indiana Supreme Court. And it hasn't happened in a long time. I know when we were talking about original actions way back in January and February, I said this, but it hasn't happened for a long time. But there certainly was a period where you had an original action and the Supreme Court would sit there as a trial court and hear evidence.
Oh, I remember you saying that. Yeah, that's crazy that there can be a finder of fact in an original action. That's unheard of.
So essentially, she just gets to make that there's no like set there's no set amount of anything that like where she can she has
No.
to go one way or the other? Do you know what I mean? Like, how she just decides on her own personal.
Yeah,
The way, that's why I want to go back to how it's supposed to happen. So you get a good judge, and they're familiar with the rules of evidence. They're familiar with the cases that interpret that rule of evidence. They're familiar generally with the facts in those cases. So a good judge doesn't pull this shit out of their ass, and a good judge doesn't just look at the reading, the exact words of the rule of evidence, because they're meaningless without the case law. You've got to have the cases. Explain how a good judge makes evidentiary rulings.
Travis, they're not meaningless without the case law. The case law, so the case law is appellate law, and a ruling on a 403 ruling is reviewed for an abuse of discretion. And an abuse of discretion happens when, I think Easterbrook on the Seventh Circuit probably said it best. An abuse of discretion happens when the judge A gets the law wrong, or B does something that's just basically crazy. And
be that as it may.
And so that's the floor. That's the floor.
Okay, Teresa keeps asking, she asks it in the context of goal, but take goal out of it. How does a judge make the decision whether something, we'll use this 403, is it's relevant, but the prejudicial effect substantially outweighs any probative value? How does a good judge make that decision? Or does he or she just make it up? She's trying to understand how judges decide this stuff.
It might be one of the sort of points in what judges do that's kind of the ultimate job of judging. It's just what judges do. I'm going to weigh this, and I'm going to weigh it my way.
It's like, how does an umpire judge balls or strikes, right? They get the best angle. They squat down and get the best angle they possibly can, and do their best, right?
Oh no, because you absolutely know if it's a strike or it's a ball based on where the ball ends up going over the plate. So
why are calls reversed? That's the intent.
But there's a rule to it, is what I'm saying. There is an actual guideline that an umpire is supposed to follow. So does judge, like a Judge Gull or any judge, have something that says this makes this evidence so unfairly prejudicial that I cannot allow it in? No. There's the line.
The guideline, look, this goes to what Travis is saying. No, the appellate guideline for that is going to be, you can basically do anything you want as long as you don't get the law wrong or you don't do something that's pretty much crazy.
So then it means that the appellate judges would just have to say, we disagree with where she drew the line on this information.
They'd have to say, so the standard of review so it's a discretionary ruling by the trial court. And so it's reviewed for an abuse of discretion. And so, maybe after this is over and I'm a little less loopy than I am from having had everybody's favorite procedure today.
Ooh.
I don't remember the case that was reversed on 403 grounds, but that said, I think that the way this would get reversed, which would kind of hook up 401, which is about relevance, also the third-party guilt cases, and 403, is the court would say, you can't possibly have weighed this correctly because you got the law wrong on the third-party guilt stuff, which was admissible evidence. And if Rick Allen's confessions are admissible, why aren't all these other confessions admissible? And let me tell you something. If he had what he thought was an airtight alibi, I guarantee you that his confessions, Nick McClelland would still get to put in the confessions, to defeat that alibi, as airtight as it might be.
True.
And look, there's this great movie, Ninotchka. I think it's called Ninotchka, when Greta Garbo's in it, and I forget, I don't know, is it William Powell or somebody is looking down at her, and he says, "Ninotchka, Ninotchka," and she looks up at him and says, with her Russian accent, "Darling, you repeat yourself." And I can't. I can't get my mind around. I mean, she would have been reversed. She would have absolutely been reversed in an interlocutory appeal. Absolutely reversed.
So you think they would have taken the interlocutory appeal on if she had certified it, that they would have the appellate court would have actually looked at it in time?
Oh yeah. Well, I don't know about in time. I mean, I think the trial would have been delayed.
Interesting.
But it's not as much delay as there's going to be an expense from having to do it all over again.
So what do you foresee happening at this point? Like what do you think we're just going to go to trial and they're just going to try to bring in everything that they can? And like you were saying, that the order from Judge Gull is a preliminary order. So as soon as like other stuff starts happening during the trial, obviously, most people just like kind of generalize it as an open door, like, but that she'll be like, okay, I see where you're going, and I'm going to let you kind of go this far based on where I see what's happening here at the actual trial.
Well, yeah, I mean, I think, look, I don't know whether they're going to try for an original action. Boy, I sure would. But it's only, so they've got 3 lawyers now. I don't know who's willing to step up to do an original action. I'm kind of swamped. I would certainly help out. It's not really complicated. But otherwise, yeah, they go to trial and I just think they have to be ready with all the witnesses and the other thing they could do, and it would take a lot of time, but what they could do is like get all their witnesses together and have them all execute affidavits. This is what we testified to.
So that their operative proofs are already ready to go, essentially. This is what we would say. Yeah.
From the witnesses themselves, not just, look, the problem with having the lawyers to sort of summarize what the witnesses would say is they're going to leave stuff out. They just do. They just will. I mean, anytime you repeat something anybody else said, almost, unless you're right, unless you're a pilot repeating back to air traffic control the instructions you just got, most of the time when you're repeating something somebody else said, you're leaving stuff out. And yeah, I don't know. I mean, they're the trial lawyers. They're really good trial lawyers. Don't know what they're going to do or how they're going to do it, but boy, I sure would have everybody ready to go. Because the other thing is, she could let them in.
Right. That's what I was saying. Since this is technically preliminary, who knows what, who knows how they start testifying, how the witnesses start testifying, and she's like, all right, I see what you got. And I see, I mean, it's the only thing I can think of at this point.
Okay.
Well, and you also don't know what was, they may have other stuff that they didn't put on. So that was a trial run. And now they have, they can put together more stuff to, maybe convince her. It was really crap.
Are you familiar with this 2002 Hernandez versus State Indiana Supreme Court case? It's real brief. When the prosecution seeks to prevent an accused the opportunity to present other versions or possibilities regarding the alleged crime, either through cross-examination or his own witnesses and exhibits, they are urging the court to commit not only an evidentiary error, but a constitutional error from which prejudice is presumed. Hernandez v. State, holding the burden switches to the state to rebut the presumption by showing the error was harmless beyond a reasonable doubt.
Yes, it's Chapman. It's Chapman, right? It's a constitutional violation, so it's Chapman harmless error, which means the state has to show that the error was harmless beyond a reasonable doubt. And here's the only way. Here's the only way the state's case survives, and I'm not saying it's impossible. And the way the state's case survives is the state argues, the deputy attorney general assigned to the case argues, and the state appellate courts buy that Rick Allen's confessions are such overwhelming evidence of guilt that all this evidence wouldn't have made any difference.
Yeah, and the point being, I mean, that's like an excellent, extremely strong case supporting what you've been saying about how off kilter this decision is, and that it's very likely going to result in the case having to be tried again. It's there in a nutshell. And I'm reading from the Memorandum of Law in Support of Admission of Evidence of Alternative Theories of the Crime and Third-Party Perpetrators, filed by the defense on August 15th, before the court had ruled. And she said she relied on this filing, or she considered it as part of her before ruling, so she didn't reject it. I like the way that they added alternative theories of the crime. That's good to expand it beyond third-party perpetrator, third-party motive evidence. That, they pointed out here that, there's a fundamental right, and you're inviting error to ask that it be excluded, either through cross-examination or his own witnesses and exhibit. It's for everybody out there listening that, this is the type of case Michael is relying upon to make those kind of statements. It's not pulling things out of thin air, and it's very, very, very troubling.
It's impossible to explain. I mean, it's just.
See, Teresa, I'm going to quit trying. You heard it right there. I mean, you just, how does she do it? Nobody knows. It's like thermos. How does it keep it cold? And how does it keep it warm when it's soup? Nobody knows.
I mean, I can really only come up with one explanation, and that is that there's a thing out there, and it is a thing. I call it black robe fever. And, she's been suffering, she and a lot of judges have been suffering from it for a long time. And they think their job is to do what they think is right.
Yeah, we have that too. I guess it's airborne, but yeah, we have that exact same thing here. Everywhere I've practiced, really. So maybe it's
And
congenital. I don't
and
know.
and I gotta say, and I have a case. I know of a case in which she didn't do the legal thing for sure, but for the guy, it might have been the right thing, but she still shouldn't have done it. It was a death penalty case. The guy's name was Marcus Sanders, and she did to his private lawyer, counsel of choice.
Yeah, we've talked about that case. Yep.
She did exactly to him what she did to Brad and Andy and removed them.
Yep. But the
And she did,
difference was the new counsel that was from the public defender's office. They filed on behalf of the removed lawyer to get that to get the appellate court to say that that was improper. They filed a request for interlocutory appeal, and Gull granted the certification to take up that issue, which never went anywhere because they Mr. Sanders pled when they took an agreement to take death penalty off the table, and he pled to a life sentence, or what in effect would be a life sentence. I can't remember what it was. He ended up pleading on that, so the issue never went anywhere. That's that case, Teresa, and we've talked about that before.
but I'm making a different point about it, and that
Well,
is,
no, I know the point you're making. Judges can put a case in a posture that really the only choice of defense counsel, or it could be in a civil case and you're representing a plaintiff. Judges have the power to put a case in a position where you have no other choice but to settle it under unfavorable circumstances.
no, that's not the point I was making. The point
Oh.
I was making about it was that she may well have thought, and with reason, that the private lawyer who was handling the case was out of his depth, and that by removing him and getting a couple of public defenders in, actually a couple of experienced capital public defenders in, this guy was going to be better off, and not only better off, she was going to avoid in a capital trial all kinds of ineffective assistance claims, and so she's doing the right thing, but it's not the legal thing.
Got you. I agree with you. That could very well have been the motive in that case, because in that case with private counsel, the issue, she had an issue with the private attorney and his diligence in getting a mitigation expert hired. And
well, she had a bigger problem with him though, too, and that is he'd filed 2 motions for her to recuse herself, and she should have. I mean, she cut off. So there was a witness that he wanted to add to his list. Witnesses, I believe it was adding somebody to a witness list, and it was inside some 30-day deadline she'd given people. Well, outside the 30 side. Well, inside, outside. It was beyond the 30-day deadline.
Yeah.
And he pointed out that in some other cases, there had been 30-day deadlines, and she'd said to those lawyers, yeah, it's fine. It doesn't matter. I don't care about it. And why is she doing this to him? And, I thought he had a pretty good beef, especially in a capital case. But it wasn't until after, it was immediately after the second motion for her to recuse herself that she popped him. But anyway, yeah, you know, Brad and Andy are going to come up with something. You know, we've come up with some, and I say we, I don't mean we with them. I mean we with some other people. Have come up with some pretty interesting stuff. We've been feeding them, and you know what they do, whether they use it, what they do with it is up to them. Again, I want to make it clear. I send stuff in, I get nothing out. I do get. I'm sorry. Maybe I'm violating the gag order because they say thank you.
I think that's
That makes me part of the defense team.
I don't know if you cut out, Michael, or if.
No, he's still there.
Okay.
Are you there, Michael?
I'm absolutely still here.
Okay.
So I got to get going, T. I'm so glad you popped in, Michael, because before you did, I said several times, this is the type of stuff that brilliant guys like Michael think about.
I think Travis is your number one fan, Mr. Ausbrook.
Oh, I've been for a long time.
At least I'm glad there's one fan out there. There's been a little brutality, but
I think
there is.
It goes along with the case, and I think the closer we get to trial, I feel the tension from people that cover this in the social media realms, and so it kind of is what it is, and people don't always agree with us, and that's just, there's nothing you can do. You can't force people to agree whether you're right or wrong. You know what I mean? Yeah. And sometimes they won't agree with you even when it's in black and white. So it just kind of.
No, but I'm talking about stuff that, people out there saying that Kara Winicky and I are like in any way being unethical, and making up facts to sort of support that. All the amazingly wasted time on plea agreements coming. I mean, there's no plea in this case. It's a life sentence for Rick Allen. And nothing he would plead to is less than that. So, but
yeah,
to go back to the stuff,
there's a lot of creators that have absolutely, even though supposedly they have advanced degrees, including legal degrees, that have absolutely no idea what they're talking about. It's clear that they've never handled any significant criminal case, and have and been in a courtroom regarding that, and the stuff that I was hearing originally, I can sum this up very succinctly. People were saying, "Oh yeah, I heard on this particular channel or this creator, this Frank's motion. What's in this Frank's motion about the descriptions of the crime scene and the descriptions of the crime scene photos, absolutely unethical." And I went, "What? Wait, how you got to be able to explain to the court why, even if the court doesn't agree with you that there should have been more about particular topic pursuant to Frank's, that it's was misleading by omission, which is rare. Usually it's outright lie in the affidavit, but you got to be able to explain it. Oh no, this person, they're talking about that, absolutely ethics. And then I started, no, that's just wrong. I'm sorry. No, this guy's saying, and it's unethical. I'm like, no, it's not really. You're allowed to argue what things mean, whether there's a gag order or not. You may need to use a pseudonym by using initials because they're minors, but that's about it. No, you can pretty much explain what's in the crime scene and why it fits with your legal theory that there should have been more information given to the judge under Franks. It's not unethical. In fact, it's the opposite. No. And then finally, the Princess of fucking Darkness, the attorney that handled the first original action, who handled the stuff under the Indiana Access to Court Records Act, and helped build a proper record for the second original action by making the demands for the transcript and getting that filed and showing what the court did. Her brief, and people just they don't remember this because, you know, she slit their throats and they didn't even realize it until they turned to look and their heads fell off. I mean, she's just that brilliant. She attached the Franks motion, which had been redacted and filed under this, newly created procedure that Gohl later said, was the idea of the clerk. But this Franks motion that was against ethics, violated all these rules. PFD filed an unredacted copy of the Franks motion, the full Franks motion, as Exhibit 1, or one of the early exhibits, as an example of what the court was trying to prevent people from seeing, and totally and utterly improper. And, people will grasp the significance of that at various times, depending on your background. But basically, she took something that the court said, I'm sealing, I'm redacting. She was so sure of her position, she unredacted it, filed a full version, and said, look, Supreme Court, look at what this clown judge is trying to call something that needs to be redacted. And and what was the court's response through her lawyer after the AG decided it had a conflict? She got her private lawyer to represent the court. What was his response to that outrageous, totally unethical action of filing an unredacted Franks motion as part of her original action? Apparently told his client, the court, yeah, you messed up. Get this stuff fixed quickly, and we'll moot that original action, which just means fix everything they say needs fixing. They're right, you're wrong. Get it done, and then there won't be anything to work on. But it's a red hot mess in terms of the court, and it's even a bigger red hot mess that there are people out there talking about. Doesn't bother me that they talk about things, but they talk about things like they know, and they're in the know, and they know things that nobody else knows, and they know about these connections supposed that don't exist. They know about legal ethics. They know about legal ethics in Indiana. They know about criminal procedure in Indiana. And that we are so fortunate to have people like Hennessy, who has spoken on a couple of the content providers. When he was first coming on, one of the providers, people were asking in a chat like this, but on a Facebook page, who's this Hennessy guy? And I said, what's he got to do with anything? And someone said, oh, well, he's representing those lawyers, and people were commenting snide and back. And I posted in there, David Hennessy is a lead pipe carrying motherfucker. And there's one those exact words. And there's one in every state, at least one, that they've devoted their entire career to the defense of people, fellow citizens accused of crime. They devote their entire careers to helping new lawyers understand the law and be the best they can be in terms of representing citizens accused of crime. And they're very, very good at what they do. And that's David Hennessy. And then the same is with Ausbrook. Ausbrook started poking his nose around in some of these chats. And yeah, yesterday I was saying, all of his accomplishments and what he does. Yeah, I'm a big fan of his, but all of his accolades are very well deserved. One is being on the national data bank of exonerees, and which is run by the University of Michigan. Ausbrook's there, and let me tell you, that's a big freaking deal. And everybody in post-conviction in the United States, that's anybody, knows who Michael Ausbrook is. So I rest my case on that. Thanks for being here, Michael, sincerely.
Now Michael wants to talk.
I just want to say something.
I'm done. I rest my case.
I think I want to say something else about Dave Hennessy that I don't think most people know. And that is, so Dave Hennessy's, for his career, was a private lawyer. I mean, he was appointed in some cases for sure, but he was a private defense lawyer. But for decades, he was involved with the Indiana Public Defender Council and was for a very long time on the board of the Indiana Public Defender Council. And he has done more for training of public defenders and improving the quality of public defense in Indiana than anybody. Except for maybe Larry Landis, who was the executive director for many, 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 many years of the Indiana Public Defender Council. The two of them together, and I mean, and that's a position and hours, and I mean thousands of hours over decades that he didn't get paid for. It's just something he did. And that's besides being the unbelievably remarkable lawyer he is. Having finished my peon, though, to Dave Hennessy, I sort of got the idea that this is wrapping up, and I wanted to maybe leave your audience, Teresa, with the following thought or question. And that is, in what world does the geolocation data on the bridge guy video and the Snapchat picture of Abby come in and the Haran testimony does not?
I think that's an interesting question. But Haran is the one who did the geofencing in 2017. So they don't want any of that talked about regardless. But I agree with you. How do you bring in the fact? Well, the Abby picture is going to be interesting all on its own because that's the one that they supposedly couldn't find on Libby's phone.
Yeah, but let's just use the bridge guy. I mean, let's just leave it with bridge guy. And they said, okay, well, it was at the high school, and then it was at the other closer tower, and they say it put her on the bridge. So how is it that data is so precise that we can say that, but Nick McClellan can come in a pleading and say, oh, this geofencing stuff, I mean, it could be anything from 1 to 5 miles. I mean,
well,
really.
It blows my mind that he has the ability to say that it's It's basically junk and not to use it, and it's just going to confuse the jury.
Well, and that without expert testimony that it's junk, right?
Right.
Without expert testimony that it's junk, Gull keeps it out.
Yep. It blows my mind. I don't get it.
Well, I said, I think I said in a tweet, yeah, you're going to keep keep all this evidence out because of the danger that it's going to confuse and mislead the jury into thinking Rick Allen is innocent.
Yeah, we don't want that. We can't have that confusion with the jury where they actually have the option to see all the evidence and make a decision for themselves. We don't want that.
Were that to happen, they would have been confused and misled.
Right.
So yeah,
because I just wouldn't understand why Richard Allen's phone was not on the geofencing.
Yeah, there are a bunch of interesting questions in that regard. Cheyenne says she saw Tara in the car with Derek. I'd like to know when that was and where's her phone.
So the interesting part about Cheyenne, and it's tough because there was a fake account that was made of Cheyenne, which I've always said I'd love to be able to actually talk to her and hear, like, how many of these social media things did she actually put a fake person pretending to be her put out there? Because we know for sure that there is at least two. But she, in one of the statements, she says that as she's leaving, she saw a man and a woman in the car, and she thought it was actually a drug deal going down, and so she leaves. Uh-huh. Now, is this the real Cheyenne that says that, or is this a fake account saying that they are Cheyenne that says that? I can't answer that. But at the time she's leaving, the only other person there would have been Tara, because according to Becky Patty, she had left and gone over to Anna's house because she couldn't get Anna to answer the phone.
Yeah, but then you have the question of how Tara got there.
We're gonna have to go back.
Anyway, I want to, maybe people in your chat have seen it. Maybe you know something about it. There's something I've seen that I'm suspicious of for a number of reasons, but there is somebody who claims that they were still out there searching at 2 a.m. and heard screams.
Correct.
Right. And that they called the sheriff's office, and the sheriff's office claimed to have been too busy to come out.
Correct.
And I'm suspicious of this for a number of reasons. One, in what world, after there's been a search all evening for two missing girls, does that lone person left in the sheriff's department at 2 a.m. say, yeah, we're too busy? Second, why, if you're out there searching and you know other people are searching, aren't you screaming for them? I mean, it all just sounds very fishy to me. I mean, it just doesn't.
I agree with you. Goes along with a lot of what we've learned about this case over all the years.
Well, but I mean, it's look, I actually, I actually don't think it was the killing itself was a ritual. I think it was dressed up, but that's Perlmutter. She can, everybody can have their different opinion about that, but right. But I don't think it's deniable that the scene was arranged, and it was quite elaborately arranged. I mean, the people were saying, "Oh, twigs fall," leave sticks fall in the woods all the time.
They just fall from the tree and land in these particular patterns.
Yeah, when we go through that, it'll be another night because I got to leave in a couple of minutes. But we got her testimony marked up that no, they weren't able to. On cross, Nick did try and point out, the blood on a tree. She acknowledged, yeah, I'm not a blood spatter expert, but I've seen enough, and that doesn't look like casual. That looks like it's put there intentional. And he tried, well, blood spatter. Now you still offer an opinion on that? Yeah, I disagree. It doesn't look like that to me. And yeah, I'm not an expert. I'm a generalist. I'm not an expert in that particular area. I'm a generalist. Look at all aspects of crime scene analysis and investigation. And so, yeah, he made some points, and we'll go through them, but no, it's not like some people have described it. But on the other hand, I'll point out some things that I don't, to me, she's not like the expert of the century, and there's some spots to exploit, but that's for trial and cross-examination by the state. And they like Michael's been saying about the legal merits of her being able to testify in order to support the defendant's right to put on a defense on what the alternatives might be.
With admissible evidence.
What he did at cross didn't have anything to do about the judge letting her in or out. It just, she just made this blanket ruling from out of nowhere that I just can't explain.
And on that happy note, maybe we should call it an evening at 11:21.
Well, we're gonna do a part 3 then, because this is actually part 2. We'll do a part 3 where we're gonna go through everything Perlmutter and all the information from her testimony and what is deemed as, probably layman's terms, good for the defense and good for the prosecution.
Yeah.
So we'll set that up.
Yeah, and I mean, one thing to talk about when you get to that, I think, is that her testimony is really not inconsistent with, the FBI's BAU take that, it was an undoing. She just is looking at it on the front end. Okay, it's a ritual killing. And then the undoing could be making it, maybe it wasn't a ritual killing, but it was dressed up afterwards, which would fit the undoing thing. So,
Right.
it could be either. I think it's more likely the latter. But, Libredo certainly thinks it was that it was an actual sacrifice. So who knows?
Yeah, he was pretty adamant about that, and which is like, I was never really on the legitimate sacrifice side. So I'm like, is there some piece of evidence that we don't know as the public that really pushes this defense team, including a Libredo, over to like, it's absolutely is. So I'm like, maybe they have something that they're like, no, this is, because he was adamant one girl was sacrificed and the other one was essentially just in the way.
Look, I've said elsewhere, but I'll repeat myself again here. I mean, there are a bunch of things that have me pretty clearly convinced that Rick Allen had nothing to do with this. And I understand, Teresa, lots of people are more on the fence, but I think of it this way, in part, and that is, we know Brad and Andy think he had nothing to do with it.
Mm-hmm.
Okay, they're the defense lawyers. Well, if you send Lewis and Clark out so we've not seen the discovery. You send Lewis and Clark out, and they come back with a map and tell you where the Missouri River goes. Now, you might think that they were lying in order to tell you that the Missouri River really goes, way south of this mountain where they found a pile of gold. And they want to go back and get the gold for themselves. But when you send Lewis and Clark, 2 different people out, and they come back with the same map of where the Missouri River goes,
Right.
You still haven't been there. You kind of think the Missouri River probably goes there.
Right. Well, that was my first, with his interview was the first time I was like, wait a minute. So ultimately for me, I just want the right person to be put away under the right circumstances. Like, I want a jury to see all the evidence and the information and make a decision based on, I don't want stuff hidden from them. I think that they should have the opportunity to see everything that there is and go, okay, this is what we come down to. And if the jury of 12 of his peers finds him guilty, does it mean he's actually not factually innocent? No, but I will feel better walking away knowing that a jury had all the information and was able to make a decision versus that they got half the information and everything was hidden from them, and then they still find him guilty. When other people are going to walk away and just cheer because it's like, yay, they think justice for the girls. And I think, no, there's no justice for the girls because we don't really know if they have the right guy. And now these families that everybody supposedly cares so much about are stuck in court forever.
Oh, yeah.
I don't know.
Oh, yeah.
The direct appeal won't be decided for 2.5 years after the sentencing.
Right.
But
didn't Lewis and Clark need a woman to keep them on track and going in the right direction ultimately?
But I have what I think. I have. The jury's not going to hear all the evidence. The juries never hear all the evidence, and one of the pieces of evidence that they're never going to hear is that Rick Allen has absolutely zero criminal history. The other piece of evidence they're unlikely to hear, I won't say won't, is that Rick Allen, for 5 years and change, as a CVS manager, was in a store across the street from the sheriff's office with a picture of Bridge Guy there, a reward out there that grew to $250,000 from, and nobody in the community who was in that, the only pharmacy, the only CVS in 30 miles, somebody said. I think that's probably an exaggeration, but maybe not.
It's close to it, I think. It's not too far. I think there's one through, so I don't know how far that actually is. That nobody even falsely turned him in as Bridge Guy to get the reward. And that I think we've got it out there in the public that this guy who's 5'4", on his way home from his mother's with no criminal history on a sunny February afternoon, says to himself, I have my gun, I have my saw, I have my knife, I have some yellow rope. I'm going to go kill two teenage girls and dress up the murder site
and that seems to be representative of something I have nothing to do with and know nothing about. I mean, I'm sorry. It's just it beggars belief.
All Eyes wants to know why you think that RA was coming from his mom's house.
Oh, that's out there someplace. I don't remember. I can't keep all the sources straight, but I think it's pretty.
I've heard that he came from his mom's. I've also heard that he was coming from his mother-in-law's. So I mean, Peru.
Well, maybe it's his mother-in-law's. My understanding is it was Peru. If it's his mother-in-law's instead of his mother's, fine.
Yeah.
I mean,
but we've not publicly been confirmed that, but that's always been the speculation.
And I don't think it's a material difference.
Right.
The point is, he's got a day off. It's a sunny, warmish afternoon. Yeah. Oh, I'm gonna go. Oh, yeah. I've got all the tools. Let me go kill a couple of girls. And by the way, I've never done anything like this before. And I understand. There are serial murderers out there. The Gilgo Beach guy. I mean, he had no criminal history until he was discovered. But you also don't have, a series of murders in the area that go to Rick Allen, and the idea. I mean, Rick Allen moving Libby around at 210 pounds. I mean, the whole thing is just. I mean, you can't make this stuff up, except that you have to make it up because it just couldn't have happened.
Essentially, him and Libby would have been right around the same height, same weight.
Yeah, maybe. And one of the things I've got, people talking about Keegan Kline. I don't know where he actually was at the time, but I was obviously, like everybody else, interested in the Keegan Kline connection. I may still be interested in the connection, but once I finally saw some video of Keegan Kline, the idea of him moving himself around that terrain was just.
I've always said that, Michael. I've always said, like, could you? Keegan Kline is just not going to be going up and down any of those hills. I don't mean it mean. He's just not going to be.
No, I don't mean it meanly either. It's just.
I was not interested in the Keegan Kline stuff. Once maybe right at the beginning, but Keegan Kline is actually why I ended up leaving covering the Delphi case, because so many people were adamant that him and his dad were the people, and I was just like, I don't see it, and I'm gonna bounce. I left. I'd stopped covering it.
Well, there are still some fairly interesting ways he may be connected. And that's all I can really say. I'm not saying he was there and did it.
Absolutely not. I don't believe. I just think. I think he's just a weird dude that.
Well, you're one of the fact masters in this. Do you know where he was on the 13th and 14th?
They throughout the last testimony when with Vito actually states that they did find him, that he was just at home, that his phone was at home, because he told them that he had driven to Delphi with his dad in the red Jeep, and he sat in the Jeep while his dad went out and went for a walk, and so he thought his dad was Bridge Guy, and then ultimately I think they were both found to be just at their house.
So they were in. He was in Indiana.
Yes.
Yeah. Okay.
Mm-hmm.
Okay. Well, I don't know much more. I definitely repeated myself too much already, and
you did not. You did great, and I thank you so much for coming up and giving us your insight. And it's invaluable. And whether people want to give you shit or not, I mean, I don't know. I don't know why they would. Your track record speaks for itself. So. Just take it with a grain of salt, and we appreciate you, and we appreciate you sharing your knowledge with us. So,
well, it's I spend when I'm not doing this, it's so I'm working on this I'm working on a big 25-year-old case, multiple murders as well. And it's just easier to prevent a wrongful conviction than it is to undo one. And, I go a little farther than you do. I'm still persuadable if they were to come, Nick McClelland were to come up with something like convincing evidence that weren't the raving confessions of a madman. I could be convinced that Rick Allen did it, but I haven't seen it. And
Well, yeah, I'm with you. If I had to sit on a jury right now with what we know publicly, there's no way I would be able to vote guilty. I just wouldn't be able to with what we have. But I'm not. There's the big, to do that. There's other evidence that, of course, the defense isn't going to tell us because it makes Richard Allen look guilty, and then the prosecutors keep him close to the vest for trial. So I'm like, okay, if that's the case, then let's go to trial. Let's put it out there, and then if there is something, I can't fathom what else there really could be if you're trying to keep out all the information about where he truly was at the time, or lack thereof, with your geofencing. I can't come up with, they don't have him on camera somewhere with his face saying that he was there. Otherwise, they would have found him years prior. I mean, otherwise, we're just talking that they just really messed up the evidence and didn't find that until 6 years later. You know what I mean? I just can't figure out. I can't figure out what this quote unquote bombshell is going to be that's just going to tip me over. So, but I'm willing to. I'm waiting. I'm waiting for it. I don't trust the investigators in the Unified Command that they did this ethically and morally, and I'm waiting to be proven wrong, and I'll happily be proven wrong if the right killer of the girls ends up put in prison. That's it for me. Like Copfax says, we all just want a fair trial. I think at the end of the day, we all want a fair trial. We all want the right person or persons to be held accountable for this. Just social media just becomes so divided that it causes a rift. But ultimately, anybody that you talk to wants the same thing. We just all want to go about it, I guess, a different way. So, but I thank you, Michael, for coming up. Travis had to drop down, but Travis, if you're listening still, I sent you a private message to thank you personally, but thank you for all of your time, and Michael, all of your time for coming up and, like I said, sharing all of your knowledge with us. And I think he may have lost his connection. So, but we're going to wrap it up, and I'm going to schedule the thumbnail on this was to talk about Perlmutter and the testimony, which we were going to do last night, but we get talking about so many topics because this case there's so much to it. So we're going to have to do a part 3 for the Perlmutter stuff, and I'll change the thumbnail. But I appreciate you guys. I mean, it's Friday night. We're going into the weekend. I thank you guys for being here. Thank you for all the birthday wishes. Thank you for the super chats. And as I always tell you, I know that you guys have so many other places you could spend your time, and you choose to just hang out here with me. And I feel like tonight it was probably for Travis and Michael, but whatever. I'm going to take the compliment for myself. And I appreciate you. It's extremely humbling that anybody here cares what I have to say. So thank you guys. Thank you guys for listening on the replay, if that's where you are. I'm barbecuing tomorrow for my birthday and my daughter's 14th birthday. So she's getting all old on me. And then we'll be back hopefully Monday. I would like to do an Idaho 4 live to catch up on everything that I have missed this week with that. And then we'll have Travis come back on. And I still need to hook up with All Eyes and set up our fundraiser for the remaining transcripts. So love you guys. Go enjoy your weekend. And I will talk to you soon. I'll probably see you on the YouTube streets or the Facebook streets one way or the other. But go enjoy your weekend. I'll talk to you soon.
Do you dare to follow me down? Head into the unknown. Down the rabbit hole. Where it stops, no one knows. We're going down. We're going follow me down. Head into the unknown.